My lord,
Substitution in contempt.
my,
Are you sure?
yes, my lord. Appeal has,
Substitution can be done.
my lord, in a appeal substitution has already been made.
Contempt substitution.
My, this person died, my lord.
Is the
One,
personal wrong?
one person is already there, other is died. To
Give, let us see. Oh, petitioner ka substitution. Petitioner has died.
one petitioner died, one
Petitioner. I just thought contempt.
even
Application. Yes.
May I mention one application?
Yes, yes, all the applications, please give.
My lord,
Order 41.
my lord, withdrawal of the appeal.
All applications give first. Let us see.
For admission.
application.
Just applications give. For withdrawal.
My lord,
Order 41, please give all. Give all order 41. Yes.
hearing matter.
Hearing matter. Which appeal?
My lord, first appeal, my lord.
Of which year?
2022.
There are many
Well,
first
I'm
appeals.
telling you, my lord, this is the money suit.
Which suit? So what is that?
Suffering from my small businessman suffering from my lord, the suit was dismissed only on the ground that the
That we do not have the money suit. What is a?
well, no money, my lord, cannot continue the business.
Don't know when we'll be able to take. Hey, year wise to kora ache appeal ko no. Ekdom diye dao.
My lord, under
My
the
lord,
head hearing,
may I
my
be
lord.
permitted to
Under the head hearing, my lord.
my lord, may I be permitted to mention, my lord, withdrawal of an appeal, my lord,
Kisei thakbo. Thakbo.
my lord, withdrawal of an appeal, my lord.
Oh, all welcome.
89 years old, he don't want to
What
proceed.
we don't have to say, sir. Your mentioning is
My lord,
accepted.
my lord.
That's all.
Oblige, my lord. Under compelling circumstances, my lord, I'm mentioning this first appeal to be listed as to be mentioned. My lord, to be mentioned, I'm seeking, my lord. Only for the reason, my lord, there were at least 5 directions, my lord, calling for LCR. My lord, a probate proceeding, my lord.
Majima, give.
May I, my lord, kindly, my lord, to mention one matter under certain circumstances, my lord. My lord, in a title suit, my lord,
I do not want to hear. What do you want, sir?
my lord, this is
Hearing or what?
my lord, for filing of an appeal without the certified copy of the my lord, lower court.
When the order was
My
passed.
lord, the order was passed in 2020, but the issue, my lord, no, my lord, the issue. My lord, kindly hear me.
Principally, once the limitation has intervened,
My lord.
we do not grant any leave to file without certified copy. Principally, we do not. Not a single matter we have granted a leave.
The only issue is, my lord.
Sorry, whatever the
before
issues
your
are,
courts, my lord.
whatever the issues are, 2021 order, more than 2 years has elapsed without certified copy. Sorry, we can't.
Okay, my lord. My lord, 1 minute, my lord. My lord, kindly,
You can exhaust your energy.
Kindly, my lord, 1 minute.
No difficulty. But we will not, we never grant. Within the period of limitation, if you come, we'll grant you leave. Otherwise,
The issue, my lord, was that, my lord, the LCR is before your lordships. There were 2 simultaneous orders passed, my lord. That is, my lord, the reason, my lord, I could not file this appeal. I could not get the certified copy then, my lord.
we don't know. We don't.
My lord, may I permit to mention a matter on behalf of the respondent? My lord, the appellant has already withdrawn the application
Yes.
before the lower court, my lord. I'm just mentioning the matter for inclusion in my lord's list to dismiss them.
It has become infructuous
Lordship, it has been become infructuous.
to be mentioned.
Lordship, may I permit to
Grateful, my
mention,
lord,
your lordship, for admission, your lordship.
Need not have to. We said order 41, rule 11, pass on. Need not have to mention.
My lord, may I be permitted to mention one matter, my lord? Item number 234 is appearing today in the daily list. The ad interim order is expiring today, my lord. If it can be extended.
Give a notice to the other side, come at 2.
My lord, upon notice to the lauded advocate for the appellant, I am mentioning item number 116 from the tase list, which is appearing under the heading matrimonial hearing. My lord, earlier on 17 May 2023, Honorable Justice, the division bench presided over by the Honorable Justice Romanson was pleased to direct the parties to file a the mutual divorce application before the court below, which has already been filed, my lord. My lord, only thing is that the learned court below is reluctant to take up the matter since the appeal is pending, my lord. My lord, let it be taken up.
Give a notice to the other side, come at 2.
Yes.
Give a notice for that. It will be taken up at 2. Give.
Grateful, grateful.
Yes.
My lord, my lord, my due to illness, I am praying for not today, my lord.
Item number?
Due to item number 288, 289 are content
These are all applications or what?
review.
That's the application. Whatever, the review application, contempt application, it's an application.
Yes, my lord.
So what do you want?
Could not, due to illness, he
Today,
could not
today
come
are
to
we
the
taking
court,
up
my lord.
applications? Huh?
Mr.
Yes.
Rafiqul Islam.
We are starting with the review. Wait, let the matter be called on. We'll consider that.
যখন call হবে বলবে।
Yes, call the start.
Kindly remember this matter, my lord.
We don't remember anything.
I'm just trying to remind your lordship. My lord, both the husband and wife before your lordship, my lord, but there is an application of a compromise. Now, my lord, husband will hand over a check of rupees 12 lakh, my lord, 50,000 in favor of the wife. This is a bank draft. My lord, both parties, my lord, are before your lordship, my lord.
My lord, I am for the petitioner, my lord. My lord, I am paying for only non-prosecution, my lord.
Oh, always welcome.
Yes, my lord. Matrimonial appeal. Conversation is going on between the parties.
Oh, that's a good news.
I am
The
for,
good news. Exactly. Like, oh, the council, have you got a written instruction?
my lord, I have filed the application, my lord.
Oh, you have filed an application.
Yes, my lord. For non-prosecution, my lord.
Oh, correct. It a can one. This is an application at the instance of the husband appellant seeking the dismissal of the instant appeal for non-prosecution. So the counsel for the appellant submits that by a passage of time, comma, the parties have changed their mind
Yes,
and
my lord.
decided to live together.
My lord.
The court appreciates their decisions. So stop. In view of the above, the appeal is dismissed as not before appreciation.
My lord.
Into women's and section 5 আছে তো পেপার বুক হয়ে গেছে তাহলেই বা পেপার বুক মনে হয় নাকি হ্যাঁ সেকশন 5 টাকা পড়ে নিয়ে আসি স্যার Yes, Mr. ASG, you have said something before the other bench about the determination. But on that basis, the bench has released. Is it covered under Group 7?
Yes.
How? Because it's relating to railways, and railway, we have a telecommunication and
This is relating to tender.
transport and telecommunication.
This is relating to a tender for transport and communication. For parcel booking,
No, I understand, but railways, are they coming into the category of a transport which we have given?
yes, because there are so many transport business.
No,
Railway,
I know, but the railways have a special, I think.
Classification under allotment of rakes, dispute regarding to rates.
Okay.
These are all classified under group 7, my lord.
Yes. Oh,
So this is a tender in respect of one parcel space.
anyhow, then when both of you are ready.
my lord, one thing I should draw your lordship's attention.
Yes.
There is a section 5 application.
So we can fix the matter
So she can fix any day, subject to lordship convenience.
my lord, next week,
because learned ASG is appearing. So his convenience and
Subject
inconvenience.
to his convenience also.
Yes.
my lord, next week, anytime.
Anytime.
Except Thursday. Because Thursday
Next-
is
Then lordship Monday, my lord.
No, next week we are heading for Thursday is the 25th.
yes.
So we can fix it any day,
24th.
24th. Yes. This matter has come up before us as the coordinate bench released the matter for want of determination. The learned additional solicitor general appearing for the appellant submits that the cause of action pleaded in the instant appeal relates to a transport which comes within the peripheral of Group 7. So, in view of the above, let the application and the appeal be listed on 24th January.
This matter was also taken up by the learned single bench, having determination to take transport and communication. The order under appeal.
Yes.
On 2 occasions, lordship, you have succeeded before the learned single bench. On 2 occasions.
That your lordship, yeah. There was an appeal taken out earlier. The appeal court set aside the
Petition,
order.
Lordship, writ petition was filed, order was passed in my.
But he
court.
said that he was also successful twice.
No,
No, in the
Ah,
appeal,
set
appeal
aside.
court,
Once.
appeal court.
That's why I say,
and again
single
it was
bench you
remanded back.
succeeded, the division bench they succeeded.
The
And he remanded back the matter to the single bench.
That is what is
Single
the
bench I have again succeeded.
So he is also hopeful that this time also the division bench.
So this time I think I have a fair chance.
When you said that you are standing in a better footing, then ESD also
So I-
proved better.
As per the Honorable Apex Court judgments, Lordship, I am standing on a better.
that your lordships will decide.
Good luck to both of you. Three. Four.
My lord, in item number 4, Mr. Orijit Chalker is appearing on behalf of the petitioner. My lord, there are 8 petitioners, but I am yet to receive instruction from 5 of the petitioners, my lord.
Said so.
That's my lord.
But this was the same. This is a repetition of the earlier.
My lord,
submission.
kindly keeps it on Friday.
Then let this matter go out of list. The moment you received all the instructions, you mentioned the matter for non-prosecution against. Yes. The counsel for the appellant submits that she has not received the written instruction from all the appellants and prayed for an accommodation. In view of the above, let this matter go out of list with liberty to mention.
I'm grateful. my lord.
Next.
Your Lordship, this is your
Withdrawal.
Lordship, first appeal, Your Lordship.
Oh, you want to withdraw?
Withdraw and file before the district judge, Your Lordship. Liberty to file before the district judge, Purba Bardhaman, Your Lordship.
We can't grant.
Your Lordship,
that,
kindly, Your Lordship, it has been wrongly filed here.
Yes. Seen the report of the stamp reporter put on the reverse of the first page of the memorandum of appeal. It appears that the order impugned passed by the Civil Judge Senior Division, Katwa, Purva Bardhaman, exercising the original jurisdiction in relation to a suit having a pecuniary value of rupees 1 lakh, which according to him is not maintainable before this court. In view of the provisions contained under section 29 within bracket 1 within bracket A of the West Bengal, Agra and Assam Civil Courts Act. No, 29 within bracket 1 within bracket A. Sorry, 21, 29, right? 21. Sorry. Stop. The counsel for the appellant fairly submits that yes, that the value of the suit is rupees 1 lakh, and in view of the provisions as indicated above, the instant appeal is not maintainable before this court. So the instant appeal is dismissed as not maintainable. Stop. Let the certified copy of the impugned judgment and decree be returned to the advocate and record of the appellant upon by the ACO upon replacement with photocopy thereof. Next paragraph. It is, however, made clear that the dismissal of the appeal as not maintainable shall not prevent the appellant to assail the same judgment and decree before the appropriate forum in accordance with law.
Grateful, Your Lordship. এগিয়ে দিন হচ্ছে তুমি দাঁড়িয়ে আছো
নার্ভাস হয়ে গেছিলাম ওই জন্য।
তুমি দাঁড়িয়েছিল অনেকক্ষণ তবে চোখে পড়েনি আমার চোখে পড়েছে
আবার বলবে এটা কি?
Supplementary affidavit.
Yes.
So the 23 documents.
Well, this section 8.
Not know, while dictating the order, I noticed certain problems.
Lordship, well,
So I was just thinking of disposing of the matter on that score.
yes.
To remember. But I noticed certain judges. Now it has came from my. But I still remember when I was reading the judgment, there were certain things which I noticed. I had a interaction with my brother as well. So I wanted that there are certain judgments which have come in the way, maybe of other high court, maybe of one of them of the Supreme Court,
David, हम seal का
which I believe can be decided only on the merits of the case. Its facts. Here we were concentrating on the law point. So corporate record is necessary.
Very well, my lord. My lord, a short point was involved, my lord, subject to your lordship's consideration that, my lord, a joint owners, they had entered into an agreement for jointly developing the property. The agreement provided that the agreement shall come into effect on the day when, my lord, the construction is completed, not before that. Now, the agreement was entered into in 2012-13. Nothing was done, my lord, for the development of the property. Then, my lord, my client, who is the owner of 75% of share in the property, my client had filed a suit for, my lord, partition. Now, the suit for partition was filed. They filed written statement. Before that, they did not make any application. In fact, even after, but
No, now I recollect.
yes,
I have come across while making my own research.
yes, my lord.
I have come across while making my own research at the time of the judgment. I noticed now I remember, recapitulative.
Yes.
So that's why I'm just disclosing it. There are two line of thoughts.
Yes.
One line of thought says that the language of the section, that is the section 8,
Yes.
is very categorical, which says that you have to raise an issue of arbitrability of a dispute before you deliver your first defense.
Very well. Yes.
So the question was that you cannot, if you have not done so at the time of delivery of the first defense, then you have really waived or abandoned or acquiesced your right to raise that. The second line of judgments which I come across was that if you have raised an issue of arbitration or arbitrability of the dispute, along with the written statement at the time of filing of the written statement also. So what they have used is, they interpreted the word before, which is appearing in section 8. Have you seen that? Before delivering of or something like that. The word before was emphasized more. That is what is the language. Not later than, what is this?
A judicial authority before which an action is brought in a matter which is the subject of an arbitration agreement.
No, I have the.
Shall, if a party to the arbitration agreement or any person claiming through or under him so applies, not later than the date of submitting his first statement.
This word not a letter.
Yes.
This is what was interpreted. That means along with the written statement, if a plea of arbitration has been taken, then it does not offend the section 8, because not later than has been more emphasized and interpreted. So there are two kind of a thing. So I really wanted to bring it to your notice that there are two line of thoughts.
Yes.
So all of you must be given an opportunity to prepare on that if you can argue, because I have seen in the written statement they have taken that plea of arbitration.
May I, my lord, may I interrupt?
So my brother has also, because
You will find in section 8, subsection 1,
Lordship.
of the expression so applies.
Yes.
What does that mean? Making of an application or mere raising of the issue in a WS?
Absolutely. I was, my lord, trying to say that, my lord, the second line of thought which your lordships are speaking about, that, my lord, the defense taken at the time of filing written
that is
statement
where,
along with an application.
no, that is what has been held by a Gujarat High Court. Gujarat High Court has said applying means the moment the attention of the court is drawn and the parties are harping upon the reference of the dispute to an arbitrator, even in the written statement. That is the word apply. So apply. It does not require an independent application. Two judgments says about the application before the written statement is filed. But there are 3 or 4 judgments of the other High Court says applies means it is a conscious,
yes,
the enforcing of an arbitration agreement and inviting the attention of the court to refer the parties to arbitration. So there is some gray area which I could find, to be very frank. Otherwise, both of us, where everybody knows our, when we interact with the matter, everybody knows that what decision we are going to take. Because that, I feel, is a more fair and a transparent manner of deciding an issue. Because if something is playing in the mind of a judges, then that must be reflected so that the parties may get an opportunity to deal. There may be a confusion in our mind to clear. So that is what we found that there are certain things. We have to say that these judgments are not applicable. These judgments are no longer a good law. These judgments does not apply. That's why we wanted both of you to come and then say, the only point is whether section 8 is fully satisfied, the ingredients is fully satisfied. If the objection as to arbitrability is raised along with the written statement.
Very well, my lord. I
That's the only thing.
I shall consider those, my lord, judgments. Only thing is, my lord, if your lordships are pleased to look into the act once more, my lord, all of us know, my lord, that the Arbitration Act, my lord, is a complete code by itself.
No doubt.
Absolutely. Now, it is complete code, my lord. The legislature could have said, instead of using the word applies, could have said that takes this point. The language could have been formed in that manner, but the legislature, in its wisdom, my lord, has said that applies.
There are 2 lines of judgments apply. Applying means by making an application or inviting the attention of the court and then harping upon that is also an apply.
And the more
yes.
The other point which
is there, it says an application.
The other point which I had, my lord, tried to bring to your lordship's attention on the last occasion also, that, my lord, arbitration agreement is restricted to, my lord, the disputes referred to in the agreement. Here, my lord, the suit, the subject matter of the suit, the compass of the suit is not governed by the arbitration agreement. The arbitration agreement would come into effect only if the property is developed. Construction made, property is developed, only then, my lord, the arbitration.
Now the question would be that what is the concept of a partition?
Yes.
Under the Partition Act, it says by metes and bounds.
Yes.
The partition must take effect by metes and bounds. Then the word metes and bound means the segregation of the larger property into different compartments.
Yes.
That is what we normally and ordinarily understand about it.
Yes.
Now, if there was an agreement in respect of the entire property to be developed, now the question is if there is a separation or a segregation of the entire larger property, will it not frustrate the entire development agreement? I am first questions, because if the sanction is granted in respect of a one premises number, if there are several premises number by virtue of a partition deed, then again the question of amalgamation of those premises has to come. Otherwise, that building plan will not take effect under the under the Kolkata Municipal Corporation Act. I do not know whether the property is situated where.
In Howrah.
In Howrah. So under the Howrah Municipal Corporation is practically a replica of the Kolkata Municipal Corporation, more or less. So in that event, I was just thinking that we not trust it. If the arbitration agreement is rendered infructuous, can it not be a dispute for the purpose? Because it's an act of the party. There are two concepts. One is voluntary act, and another is an involuntary. If it is a case of an involuntary act, no doubt, parties have no role to play. If it is a case of a voluntary act, then certainly the dispute has arisen and one has to.
No, the dispute, again, my lord, I would like to, my lord, take 2 points. Now, my lord, I filed the suit in 2016. So, my lord, I take it that his cause of action to enforce the development agreement, if at all it is in existence, because according to me, yes.
I understand
Nothing
where you are
done.
heading. I understand,
Now,
but
today, kindly contemplate the situation.
But can it be a ground now? So far as the section
Kindly contemplate a situation. Now, from 2016, my lord, no step taken. They could have appointed. I will tell your lordship the dispute. The dispute is, my lord, the two parties, the defendant, their mother, my lord, is a tenant in respect of a portion of the property.
At the time of purchase.
Please, still, till today. Now, they would be only too happy not to partition the property, because they would be, my lord, enjoying the entire thing.
No, I understand. This is what
Now,
appreciate.
They had, my lord, also the obligation. Since they are taking the point of arbitration, my lord, if I may ask myself the question, was it not obligatory on their part either to appoint an arbitrator if, my lord, the arbitration agreement provided for that, or, my lord, to apply before the court under section 11? Nothing has been done for 7 years. Merely making an application under, my lord, 5 and 8 or under section 8, my lord, does not appoint an arbitrator.
No, they do not have a power.
No. So, my lord, their obligation was to appoint an arbitrator. That they did not do. And, my lord, as I was pointing out, the agreement provides that this agreement will be effective and enforceable only
No, I understand. Please come on that point, because something has really come in our mind. So please take that plea, because what we are thinking about it is that if it is accepted that taking a plea of an arbitration along with a written statement is a sufficient compliance of section 8, then the first and foremost thing comes, was it not a mandatory duty or an imperative on the part of the court to decide that particular issue or a dispute, arbitrability of the dispute under section 8? The court should not have proceeded. Secondly, what I find is that the parties have undergone the trial, and they cross-examine the witness, and everything is done. That is what is troubling me. Is not that I'm just expressing my mind into
Commissioner also has filed the report.
I understand, sir. That is what I say. What troubles me, because I find a line of judgment which says section 8 is mandatory.
Yes,
it is mandatory. The moment a party raises an issue that the subject matter of the suit is covered under the arbitration.
It's not.
I'm coming under the arbitration. Then it is the paramount duty of the court to decide on section 8 that whether, first thing is, there is a arbitration clause. Second is the dispute referred there in the arbitration clause or an agreement is the subject matter of the suit. If it is covered, then the court, because the court has to arrive. Because of this SBP and a Patel engineering, in 2005, the Supreme Court departed from Konkan railways and everything, and says not a mere an administrative exercise under these provisions, Section 11 or Section 8. It is the judicial conscious decision, even a validity of an agreement can be gone into under Section 8 and Section 11, both. So the court can definitely go into this. So if it was a mandatory on the part of the court to go into it, having not done, whether the judgment which has been rendered can be upheld fast. Second is a special fact. If the court has proceeded ignoring this, parties participated in the trial, whether that would impliedly waive the right under Section 8. I am conscious from all angles. I am aware from all angles. That's why I was just thinking, just to invite, because if we deliver a judgment and then something we said, you say that is coming by a surprise, the court ought to have raised this issue. Otherwise, not for any other reasons. So when you can prepare yourself.
Any day, my lord, next week, my lord, if possible, any day.
What should be the suitable date for you? Because there are 2 holidays in the next week.
Oh, 23
26.
Oh, any day
3rd and
convenient.
26th.
Any day convenient.
Tell me, we can fix it on 25, 24.
Can it be, can it be, my lord, in the first week of February? 5th or 6th,
What is the difficulty?
there is some difficulty I really do not see.
Your difficulty you do not know, or difficulty of your juniors.
My lord, it's a team.
It's a team. Can you come on 6th?
Yes.
Well, in the meantime, lower court records may be called for so that the entire document. So otherwise, I have a form a supplementary affidavit that can be taken.
We don't mind.
No, ma'am.
We will ensure that it comes by 5th.
By 5th.
That we will ensure, don't worry.
That is.
Can you put a special messenger cost?
Yes,
The commissioner's objection, that would be, well, lord, stalled. The commissioner has filed a report.
We do it, sir. When a preliminary decree is there, when we call for the record, we make it clear that the skeleton records are kept by the court for the purpose of continuance. In a partition suit, we are conscious, don't worry. I am more conscious about it.
And your lordship knows, my lord,
both the councils have been apprised of certain legal issues. Which in course of the hearing perceived by the bench, and it is uniformly submitted that the matter may be fixed on some other day so that the councils may be able to answer such legal points. It is suggested that the lower court record may be necessary in answering some legal issues, but the apprehension is shown by the counsel for the respondent in relation to forestalling of the hearing of the report submitted by the partition commissioner. Stop. Considering the above, we feel that the lower court record may be necessary at the time of hearing the matter on the legal issues. But we are further conscious and appreciate the apprehension shown by the respondent that it may have a cascading effect on the progress of the suit. In pursuit of deciding the partition suit finally. The counsel for the respondent agrees to bring in to put in the special messenger costs so that the lower court record may be called for. We therefore direct the respondent to put in the special messenger cost in course of this day to bring the lower court record. So, on deposit of the special messenger costs, the office shall ensure that the lower court record reaches to this court on or before 31st January 2024. It is, however, made clear that the trial court, while sending the record, shall make a skeleton record so that it does not impede the hearing of the hearing of the objection filed against the report submitted by the partition commissioner. Stop. Let this matter be listed on 6th February under the same heading.
And now, my lord, may I make a very unreasonable prayer? Can I have the references of the Gujarat courts? Because I am not very conversant with, my lord, this
very scary.
using, my lord, this online things.
I have not used it.
In books. Very well.
So don't eye at my khata. Everybody is eyeing at my khata.
One case in Ladakh.
That's for long, not now.
No, long is still is
No.
updated.
That we know for long.
I'm
not sure.
Lord, I am appearing for the appellant petitioner. Lord, your lordships will kindly recollect in this matter on the last occasion on 10th of January.
The bank manager appeared, yes. Now what has happened? Now
Lord, last paragraph 7 of your lordships last order, kindly see. Paragraph 7.
yes. Have you taken a decision? Yes. Because they have come up with the offer that if you do it, then they are agreeable.
Because, my lord, admittedly, my lord, they have been residing, although in the same house, for about 2 decades. So there is no issue in fighting, my lord. That is why I suggested, subject to what your lordship says, that we are ready to be there. My lord, right of residence is there, my lord, your lordship knows. My lord, this honorable court, the other division bench, directed for an accommodation at the front side.
We will see as a part of the right to maintenance, the residence would be there.
Yes. Well, that is there. We have been provided, although in the back portion with some odds, my lord, that is there.
Do not realize why I utter this word.
No, my lord, only
Yes.
Well, on the last occasion, my landlord junior possibly submitted your.
What you have, sir, taken, what is decision has been taken by you? Your client has taken any decision on paragraph 7?
Paragraph 7 of your lordship's last order.
Have you seen that? That was dictated in the open court.
Lord, I shall, Lord, as per your lordship desire, my lord.
Yes.
Lord, the entire Mali, my lord, the entire, my lord, 50 lakhs rupees, my lord, he is not entitled to pay the, at a time.
What?
He has not the cash in hand. Your lordship, my lord, pay maintenance. I am entitled to pay maintenance. Your lordship knows, my lord.
So
But
you
your
want to continue with
my
the
lord, I shall pay maintenance. I pay alimony. My lord, earlier occasions, my lord, the court below, my lord, in the trial court, I already paying, my lord, 5,000 rupees as alimony.
Till the date of decree.
yes.
Till the date of decree.
I am entitled. Because, my lord, your
Not
lordship knows, my
entitled, obliged.
Your lordship knows, my lord, I am entitled to pay maintenance alimony till penalty. Your appeal will be heard. Your lordship decision may be given to hear the appeal. I shall pay maintenance. Your lordship desire. I shall pay maintenance. On month basis, but only 20,000, my lord, he is paying pension amount. On the basis of the, he is serious. I am speaking seriously, my lord. He is seriously ill. He is my lord, he has been unfit, my lord, is bodily unfit. Your lordship kindly consider the amount in question and pass necessary order. I am not disputing.
But may I make one submission?
Yes.
My lord, the lady had to undergo a my lord, knee surgery, knee replacement. In the affidavit, my lord, she has said that it requires 2 lakhs of rupees, which I do not have. Subsequently, that affidavit is on record. Subsequently, he was operated worth for 2,60,000 and odd. The portion thereof she obtained from the out of the Sastho Sathi card maintained by her, and the rest about 60,000 he has spent, Lord, by borrowing from the daughter.
Yes.
And he is at the present at the mercy of the daughter and son-in-law. And my lord, in the affidavit of assets filed by the husband, he has stated that he received the retirement benefit of 15 lakhs, round of sum. Now the bank statement comes as he has received 21 lakhs and odd. And he said, I am getting the pensionary benefit of 15,000 and odd. The bank report has come that he is receiving 21,000 and odd per month towards pension. My lord, that affidavit also, but in terms of the direction of the Honorable Supreme Court in Neha's case, that affidavit is also not wrong. And he has paid the maintenance only up to the date of decree. After that, I have not received a single copper. My daughter is giving me 2,000 rupees a month, and my elder sister is giving me 1,000 rupees a month. Lord, I am asking the question to myself, Lord, is it possible for one to survive by 3,000 rupees a month whose monthly medical expenditure is more than 2,000? That is why I submitted, my lord. It failed from your lordship. I understand that 20 lakhs. My landed junior has said, no, 15 lakhs. 15 lakhs in this sense, my lord, if 15 lakhs at the lump sum is paid, my lord, it will fetch an interest of about 10,000 rupees a month.
Yes.
For 10 years. So this is calculated for 10 years. It will come around 10,000, by which she can survive for at least next 10 years. Her present age is 60 plus. Lord, that is why, Lord, your lordship was also pleased to think it reasonable in the last occasion. I understand, Lord, that on the other hand, Lord, if your lordship gives a monthly maintenance, as your lordship knows, Lord, this battle is going on for last couple of years. Now, Lord, if 1 or 2 monthly maintenance is given, and after that it is stopped, Lord, my client has to come to before this court or the landed court below for execution in one after another proceeding. To avoid all these, Lord, let there be a lump sum, finished. Lord, let the appeal be not proceeded with. Lord, his statement apparently is wrong. On oath he has submitted which is not correct. He received the 15 lakhs towards retirement benefit, he has said. And out of that 11 lakhs he has spent for repairing of the house. A 3-storied building, he lives alone. 11 lakhs he has spent.
After all, he has to maintain a residence. Nobody would say that I'm living alone, so I do not repair.
No, I cannot say that.
I cannot
say that.
repair. After all, it's a protection and preservation
Absolutely,
of the,
absolutely
of the
correct.
property. It does
Absolutely
not mean that nobody will. So don't say so. I
Absolutely
do not
correct.
know the exigencies may be like that, he's compelled to.
But the
spend.
husband is also supposed
But-
to look after the wife,
Yes,
Lord,
why don't you
who is
look after the
deprived
wife?
of for more than 2
How much?
decades.
Pay something.
May I submit one? He's paid for 10,000. My brother, he's
I have no-
speaking, my lord, he's seriously ill. He has no money in his own hand, and he will also, I shall pay maintenance. He also, as per prayer of my learned friend, I'm going to pay for 10,000 rupees of money. He also prayer. He also kindly see the prayer of the learned prayer application.
That is the prayer in the section 24 application in connection with the appeal.
So you do not want that your client is agreeable, or your submission is that your client is not agreeable to pay a lump sum amount.
He
So,
got the position.
leave
He
it.
got the position.
Leave it. Your client is able to pay the monthly maintenance. No
As per
difficulty.
lots of these.
Whatever.
As per lots of these.
So what remained? If they do
But
not,
only-
go to-
But either way, I will be getting.
Yes.
If your lordship
So
passes that order, either way, I will getting. But fact is, possibly after 1 or 2 months, Lord, I may have to approach the executing court. That is also expensive for me, Lord. I cannot bear those expenses. That your
No,
lordship
we
kindly
will
consider.
we will also direct
Kindly
them to pay
direct them to give a lump sum because
certain amount as a litigation costs. We'll
yes,
pay-
that is also a prayer. That is also a prayer there. Lord, may I suggest one thing subject to what your lordship feel? Lord, some lump sum be given because I have already.
Not agreeable to give.
Lord, may I make this submission only? Lord, some lump sum on the ground that I have already spent more than 2 lakhs for my knee surgery. That I have to borrow from my daughter. Lord, I am supposed to return it back. Some money and the rest by monthly installment, and the law will follow. Lord, if he fails to pay,
He's paying the amount regularly to you in terms of the order of the trial court.
My lord.
No.
Yes.
Up to the date of decree 2019. After that, not a single copper. No.
Up to the date of the decree, he has
Yes,
paid.
he has paid.
So from 2019 onwards, it fell due.
Yes.
So let us think of when you filed an application.
19. We filed an
When you
application
filed
in
an
19
application.
itself.
Appeal has been paid by 19.
In 19,
And appeal has
2019 itself.
So from the date of an application at least,
From the date of
you
the
are
order?
entitled. You are entitled.
In
From the date of the application, there is no difficulty.
yes, that is the law.
So my judgment is
Yes,
otherwise.
that is the law.
But so what is the judgment of the Supreme Court? That Balbir Kaur's judgment, which says about from the date of the application or from the date of the decree, or from the date of the order. I mean,
From the date of the application, they know.
no. It says both. Where is that judgment of the Supreme Court? Very small judgment. Balbir Kaur's judgment. From which date the court will grant a maintenance? So there were two concepts. One was from the date of the application
My lord.
filed by the wife for maintenance, or from the date of the order disposing of an application for maintenance.
Lord,
So it all depends.
Lord, kindly give me 2 days time, Lord. I
In
shall.
2 days time. Balbir Kaur's judgment, everybody now, younger
Lord,
generation-
kindly keep it
younger
for tomorrow,
generations are
Lord.
more tech friendly,
Kindly
tech savvy.
Kindly keep it for tomorrow, Maharaj.
Nothing. They can immediately take out that judgment on maintenance, Balbir Kaur's. I believe so, Balbir Kaur. BLBIR, just see the Balbir Kaur on section 24 maintenance.
Ranjit Kaur.
Balbir Kaur. Ranjit Kaur, section 24. I do not know. I have a very strong Memory of Balbir Kaur.
Yes, I know that. But you leave it.
Anyhow,
May I come back at 2 p.m.?
It's not necessary. Anyhow, yes, you'll have to pay the maintenance. And this 5,000 rupees was granted when?
5,000, 20, initially, 5. I tell you, Lordship.
For deed of judgment delivered on Milord, 19. The deed of divorce judgment was passed, Milord.
Sir, I am asking when an application under section 24 was
By the
made
trial
by
court.
her
By the
in a
trial
suit.
court.
In a suit. In a suit.
Yes, from the date of the application, judgment is there, my lord. Balbir Kaur.
Yes.
BB Balbir Kaur, Kathuria versus Raghuveer Singh.
That is what I really wanted. That is a 1990.
27th November 1973.
This order was,
I think, later on.
There is a equivalent citation AIR 1974, Punjab and Haryana High Court 225.
Yes.
It says from the date of the application.
No, that is the Punjab and Haryana judgment. It went to the Supreme Court also. It went to the Supreme Court.
and
Balbir
the
Kaur.
first maintenance order was passed, Lord, in
Maybe a
2011.
Raghuveer Singh versus Balbir Kaur or whatever. Now the
Reversed.
cost title may be reversed.
Vice versa.
Otherwise, Balbir Kaur, I think she was the petitioner there in the Supreme Court. Yes, as we know, we will consider it. So when it was filed, which year the application was disposed of?
2011.
Section 24.
Section 24.
So now 12 years have passed. If you look at the inflation rate between 2011 to 2023, how much it comes?
Your judgment delivered on 19.
That is the decree.
That is the decree, sir.
That
I'm
is the
asking
decree.
about the maintenance.
That is the decree.
Maintenance was granted from the date of the application.
In 2011.
It was,
In this suit.
so it was in 2011.
My lord.
Application was allowed. We are in 2023. More than nearly 12 years. Look at the inflation or the price index. How much times it has increased between this period. So naturally the expenditure has also increased.
My lord, the
No.
poor lady is also present in court, although that is not material. That's not material.
P. He has disclosed how much? Where is the affidavit?
Affidavit, my lord, he has disclosed. The bank has disclosed. Lordship, kindly look at the bank.
They have not disclosed in view of Rajni's versus Neha or Neha.
They have also.
So
There is
what do you
some
say?
disparity. That is what, your lordship, kindly take the bank's statement first at the second page. What on the last occasion, bank did file.
That we have said 21 lakhs.
21 lakhs, and kindly take his affidavit. In his affidavit, he has said
Yes.
it is 15 lakhs. But at page 8 of his Rajnish versus Neha judgment statement, but at page 8 of his affidavit. Page 8, column 30, that's the last. Retirement benefit of 15 lakhs. Giving the date on 4/5/2015.
15 lakhs.
15 lakhs. And bank is saying 21 lakhs 90,000.
Your client is not a trustworthy client. Because the bank statement shows that these amounts have come in your account, which is much more than the 15 lakhs.
My lord, in fact, the other division bench presided over my lord just saying, my lord, was surprised to see how a man can get a round of figure of 15 lakhs.
No, that is what is.
Page 46, your lordship, page 46.
It appears to be contrary to the report submitted by the bank. This says that 21 lakh 90 and the details of the bank account has also been disclosed. And then how he has received the report statement of the bank. Next page, this.
Your lordship, can you see page 46?
This
What is
amount appears to have been credited. Gratuity of KK Dotto that has been given. If it is SBA for the by computing pensions and all everything. And by areas it has total pension, everything else.
এখানে কি বলছে টোটাল অ্যামাউন্ট সব মিলিয়ে
টোটাল বলেছে
টোটালি টোটালি তো কোর্ট তো টোটালি বলবে এই টোটাল ফিগার তো তুমি লিখছে না
বুঝতে পেরেছে কি
we can safely grow.
ঠিক আছে
So 50
lakh.
Then
My lord, it is, my lord,
much of more. This is after 4.
apart from other benefits.
my lord, it is
Order.
50,000, my lord,
15 lakh.
15 lakhs. The other benefits, my lord,
Yes.
saying, other benefits, bank saying, well, the other benefits.
Sir, we
that
have
was the
seen-
desire of the court pensionary and
Yes,
other
seen that.
benefits.
No, we have seen that.
My lord.
We noticed something from there because they have disclosed a lump sum of rupees 15 lakhs
15
on
lakhs.
4/5/2015.
Yes.
And the bank details which the bank has furnished, certain amounts have been credited after 4/5.
My lord.
It
That's
is in the month of June, certain amounts have been credited to his account. So you
Yes.
can't blame him
By
for
commutation
saying
with
that
the-
that he received after that.
by commutation and other things
Whatever he has received thereafter in June.
in June.
So you can't blame him.
No, I'm not blaming my lord.
So we will take into
Apparent
account those.
disparity.
We'll take into account those and we'll pass the order. We'll dispose of the application. He's not interested in a lump sum. So there's no necessity of.
My lord, sir, inclined to pass monthly maintenance.
And my lord,
There's no difficulty because he's not interested in lump sum. He
Kindly,
can't pay.
kindly
We
give me.
can't force. Kindly visualize.
Right.
Under the law, he's liable or he's responsible to maintain the wife.
Right.
Under the law.
Yes.
Now, how the maintenance would be awarded has not been provided in the statute.
Right.
It all depends upon the various factors. So permanent alimony is also there, but it does not say that the permanent alimony court can enforce because something has to be gone into this regard. So we can't say at this stage, but we can continue with the maintenance. And we can think of a litigation expenses as well. In the event they do not, then at least something is to be provided to you.
My lord, kindly give me moments time.
What
Where is
moment?
the lady? Where is she? Well, kind.
সেটা পরে আছে আপনি চালাতে হবে তুলবে বলে হবে না চালাতে হবে ঠিক আছে ওটা
My lord, kindly pass the order. Yes, তাই তো naturally. একসঙ্গে যদি লামসাম দিতে না পারে আমি যাতে কি করবো
Yes.
My lord, monthly maintenance, only thing, my lord, kindly put a default clause. In the event of default, my lord, some protection. Otherwise, my lord, month by month, I need to go for it.
What according to you we can put a protection? Default?
My lord,
In the case of default of any, they will be at liberty to pay for execution.
That is a right.
Otherwise, that is also,
That
if
is a
the
right.
lordship does not express that, even it is there.
That is there. That's why I'm
is
saying
always
it's
there.
a statutory right. Why we
That
will impose?
the lordship will kindly take into consideration each month, my lord, if one needs to approach for execution, property attached
Yes,
to application না
পাঠিয়ে
করলে
দাও।
করা যায়।
ঠিক
As
আছে?
your lordship
পাঠিয়ে
pleases.
দাও। We will be, this matter will be appearing as for orders in the next week. Just follow.
Okay. Grateful. I think.
And I'm not suppressing anything, but
Yes, call the next. Call the
My lord, I am
Yes, sir.
My lord, I am for the appellant society.
Yes,
My
sir.
lord, as per your, on the last occasion, your lordship I make.
Board has been constituted or not?
No, my
Have
lord,
you-
not yet, but I have taken information from the department that they have already joint register RTH is the jurisdiction of this cooperative, and they have sent a proposal for appointment of administrator, and that order has come today before the register of cooperative society.
So what to do, sir? Tell us.
My lord, I think at least 15 days time, because in the meantime, and another notice is to be given to the private respondent, because the learned lawyer of the private respondent has died. Learned lawyer of the private respondent has died, and therefore, my lord, that letter will be given to directly to the party as per lordship direction. In the meantime,
Who was the learned advocate for the private respondent?
my lord, Sandeep Bhattacharya, and here.
Sandeep Bhattacharya, we do not want the Himadri Kumar Bandopadhyay and Miss Rama Halda. They appeared for respondent number 3 and 4.
Or the advocate record maybe, my lord, but actually the case was.
Not actually. We will go by a Wakalatnama. Sandeep Kumar Bhattacharya, it appears. Who has filed a Wakalatnama?
Initially, my lord, someone was there. Thereafter, lawyer changed.
I do not know, but we do not find any Wakalatnama.
On behalf of the private respondent 3 and 4, Himadri Kumar Bandopadhyay, Sandeep Bhattacharya first, second Himadri Kumar Bandopadhyay, and Mrs. Ahana Rai. Now, the senior was, my lord, Sandeep Kumar Bhattacharya.
But the senior dies, that does not mean they are not represented. What are you talking about? Sandeep. Getting Sandeep. It is submitted by the counsel for the appellant that till date the board has not been constituted. Stop. It is further submitted that the deputy registrar who has written a letter for administrator.
Joint Register of Cooperative Society, RTAH.
The
Joint Register of Cooperative Societies, RTAH, Rajarhat Township.
Okay. It is further submitted that the joint
Registrar of Cooperative Societies
within
Rajarhat Township area housing.
Within bracket R
RTAH.
RTAH has written a letter to the registrar, cooperative society,
For appointment of.
for appointment of administrator. Full stop. The aforesaid decision has not been taken.
By the
It is
registrar.
submitted that there is a possibility of taking a decision within fortnight from date, and therefore the prayer is made by the council for the appellant to adjourn this matter. Stop. It further transpires. Now it is further informed to this court. It is informed to this court that the advocate and record of the respondent number 3 and 4 has died.
Not advocate on record, my lord. Senior who used to do this case, Sandeep Bhattacharya. That
The
advocate record is.
He has filed the application in the back.
He is Ali, my lord. Junior is Ali. Then I will serve to the learned jury or to the whatever they will.
I do not know who has filed the Wakalatnama. Sir, senior may die, but the Wakalatnama.
Obviously, my lord, maybe he must be Kumar
there.
Bandhavara.
No, it is a Sandeep who has filed the petitions on the back sheets.
Yes, sir. Yes, my lord.
So, but we do not find any Wakalatnama on the record of the Sandeep or anybody else.
My lord, I will serve the copy to directly to the parties.
One Himadri Kumar Bandopathyay, I think probably, who is this? Himadri Kumar Bandopathyay? He has been changed.
No, so he is as per paper book, my lord, he is also there. Do not know that he has been changed or not.
So, you say Sandeep was appearing along with him?
Yes, my lord.
So, Himadri Kumar Bandopathyay is alive?
Yes, alive.
Sorry, who has signed it? This is for private responsibility. Wakalatnama is here, signed by Himadri Kumar Bandopathyay and Rama Haldar. Both of them are alive. So we can't, sorry. Stop. Get it up. It is in view of the above. Let this matter be adjourned for a fortnight. Yes.
উঠে গেল 15 মিনিট, তাই উঠে জানো না, ঠিক আছে।
This was the matter in concern to Purulia district. There was grievances. This was a public interest litigation, stating that there have been several discrepancies regarding defalcations of fund concerning various social activities. And however, there was a direction upon the respondents to file a report.
This is the PIL.
Lordship.
And this has been referred to us.
Lordship.
The report has been filed by the government, my lord, district magistrate, and they have perused the report, and my lord, your lordship kindly come to March, order dated March 15, 2022. The report on behalf of the petitioner number 2 has been filed today. Annexure 15 thereof indicates that the criminal case has been started. Learned counsel, the petitioner seek time to examine the report and to file exception. Thereafter, my lord, next report, my lord. Learned counsel for the November 10 report. November 10 order dated. My lord, learned counsel for the petitioner submits that the grievance of the petitioner seems to have been redressed and seeks to.
Yes.
Lordship, we have gone through the report. We are satisfied on that part that case has
don't
only one submission, if your lordship kindly allows, that as it was started under section 409 regarding an erring officer of the state. Our allegation was somewhere that these social activities or those were done by the pradhans and the upapradhans and the that part of the step was not taken by the concerned district
But
magistrate.
there was a liberty given to
Yes,
you
my
to
lord.
take an exception. You have
Yes.
not taken an exception to the
Lordship, we
report.
have filed an exception. This was of
But if the order says that all these grievances have been redressed, then in that event, what more?
Lordship, only on this point, I'm praying for liberty that if your lordship kindly observes this, that this step was taken in connection to the state officials. However, those who were the executing
We
authority,
can't dispose of the matter.
lordship,
Then we'll have to allow your exception, and then we'll have to say that you'll have to take some steps against those people.
lordship, may I pray for only 2 days time so that I can come back with that exception, because that previous exception that was filed, that was of 19th 18th September.
His grievance is that you have initiated a proceeding against some fringe peoples, but the real man has been spared.
The report says, my lord, respondent number 2, the report which has been filed by the district magistrate
Yes.
is the elaborate report. Each and every step which is required has been taken.
Taken against he's raising a issue against this Pradhan and all everything.
Against them.
Against them also. Where is that report? Report dated?
My lord, the report is with the brief, my lord. They peruse
No,
the
no,
report
what
and
is the
thereafter
date?
They said they are
Oh, please. What is the date of that report?
My lord,
Can you?
The report date is on 24th February 2022, my lord.
24th?
February 2022.
24th February, yes.
My lord. This was
Yes.
the total inquiry was made against the state officials. No.
Development.
my lord,
No, against the Gram Panchayat also certain action has been taken. The last page of that report is
Lordship,
of that report. It is the further order dated 11/1/2022 by the Hon'ble High Court.
Lordship.
The district magistrate was directed, having due regard to the earlier order, was required to do a needful to initiate a criminal action. In compliance of the order, the district magistrate directed the block development officer, para development block, Purulia, to initiate a criminal action against Baneshwar Mahato. He is a Jivika Sevak of Poridi Gram Panchayat.
My lord.
In accordance with such direction, required to request the officer in charge to initiate a necessary criminal proceeding against Baneshwar.
My lord.
So he's concerned with the Panchayat, Gram Panchayat.
Lordship.
So your grievance is against the Gram Panchayat.
My lord. May I only humbly submit one thing, that the Pradhan was the total in charge, and we had allegations against him also.
Now the thing is that in an inquiry, it appears that the
Yes, sir.
Pradhan has nothing to do. It
My
is
lord.
this gentleman who has done.
My lord.
So they have already initiated a proceeding against him.
I leave it up to your lordship.
There may be a responsibility,
My lord.
but vicarious responsibility you are
Yes.
talking about. But after all, the real kingpin has been identified in the investigation. So he is to be booked. And what has happened? Have you initiated a proceeding?
That I have to take instruction. A proceeding has been initiated, that has been deported. This is the matter.
Oh, this is please, we are not concerned. It says that the police, the FIR has been lodged against this gentleman under section 409. Now we wanted during investigation, if some name of some other persons comes, if the Pradhan also is there is no difficulty on the part of the investigating officer in putting him or robbing him within that. There is no difficulty. But what is the stage of the investigation?
That I have to take instruction.
What
This
is
is a
this?
change, my lord. Initially,
change.
Mr. Jawaharlal Dey and Smita Das is appearing, my lord. Now the brief has transferred since they are not in the panel, my lord. So the brief has reallocated to him. And my lord, I have also not
Take an information. What you have done? Investigation has started or investigation has not started.
my lord,
If it has started, then what is the?
my lord.
Because the last sentence says that the present police investigation is on.
Yes.
What is the outcome? And
I have to take instruction.
it's the money.
Yes, my lord. There was defalcation of money, there was social activities, and first of all, there was an order
raising a serious issues pertaining to embezzlement of the public money. The instant public interest litigation was initiated by the petitioner. For a direction to initiate a proceedings against the erring officer who is found responsible for such defalcation. Two reports appears to have been filed by the government officials. The last report would reveal that they have that in a preliminary inquiry they have identified a person responsible for such dealing with the public money, and a direction is also passed to lodge a FIR with a view to unearth the real cause. Full stop. The last report revealed that on the basis of an FIR lodged by the concerned officer on the direction of the district magistrate, the investigation is going on. Though the counsel for the appellant raises an issue that the real kingpin has been spared, but we find that the moment the investigation is set in motion, the investigating officer would make an impartial and fair investigation, and anybody found to be involved in such offense the appropriate steps would be taken. There is no, there is nothing on record that the investigation is completed and the charge sheet is filed by the investigating officer. The counsel for the state respondent showed his inability to apprise the court of the exact state of affairs in view of the fact that he has been recently engaged in the matter as the erstwhile advocates representing the state are no longer in the panel of the advocates to appear for the state. You have a praise for an accommodation. In view of the above, let this matter be listed on 24th January to enable the 24th to enable the learned advocate to collect the information and disclose the same before this court.
Careful.
Yes. Which one? 288.
Lordship, I am for respondent number 1, my lord.
What is it?
Lordship, I am respondent number 1, appellant, my lord.
ট্যাগটা তো লাগাবে যেখান থেকে শুরু হচ্ছে। No.
Lordship, I am respondent number 1, my lord.
Deficit court fee has been put in. And whether section 5 has been filed?
Already section 5 application has been filed. But the question
We
is
are not
whether-
having this in our file. Can you give me the number?
Can one.
And one is a stay application, madam, as I find. Delay application, I am just asking.
Section 5 application and number.
Can one of the.
Can one to the review?
Sir, we have indicated in the last order of 11th of December 2023, we have said that the instant review application is filed beyond the statutory period of limitation. In view of the above, the applicants are directed to take appropriate steps with regard to the delay in filing the review application. So you have to. Which number?
Number can 1 of 23.
Sir, can 1 of 23. Sorry, we have a can 1 of 2022. Where is can 1 of 2023? Hey, দেখো না ফাইল করেছেন এখানে তো নিশ্চয়ই এসছে এখানে বার করুন
2023
বার করুন আপনাদের খাতায় এসছে এটা আপনাদের অন্তত দিস ইজ আ 17th or 18th টাইম আমি বলছি যখনই কোনো অ্যাপ্লিকেশন আসছে ম্যাটার ইজ লিস্টেড অলরেডি আপনারা ওই অ্যাপ্লিকেশন দেবেন না কেন
যে হবে না
কেন দেবেন না আমি এটা বুঝতে পারছি না এটা তো লিস্টে অলরেডি রানিং ইন দ্য লিস্ট হঠাৎ করে কিছু নয় I have instructed him at least 16-17 times. Whenever any application is filed and it is coming to the court, the rule is that central filing it is goes and from central filing it comes to a respective court because they indicate that which court. This is they have indicated. It should go to this. It comes to us. then why they will not include this here in the file? Correct. Why they will not include it? No, I have received now, just now. You just seen that he has handed over.
Yes.
So you have served a copy of section 5
Yes,
upon
it
them.
is with us.
How much days delay it has been indicated?
My lord, with regard to this condonation application,
This has to be disposed of first. Madam, you have not also filed the Wakalatnama.
Yes, ma'am.
Where? You are appearing for whom? You are appearing for,
Make class simple.
yes, Muhammad Azhar Hussain.
No.
Then who?
Prepare for the nodal officer.
Nodal officer means?
District nodal officer, Howrah Jilla Police. District nodal officer.
That was a party to the proceedings.
Yes, that's point number 1.
Who was representing the respondent? Sanwar Jahan and Miss Mausumi Mitra.
SSK.
You
No,
did
no,
not
no.
appear in MAT.
Sarwar Jahan perhaps was appearing for the state now?
No.
Madrasa.
Eh?
Madrasa.
Madras.
Madrasa.
MS cases.
Madrasa.
Mission.
শিক্ষা পরিষদ তাই বল
Miss Chaudhary, you did not appear when the matter was taken up by the division bench. Your name is not reflected anywhere.
Review has been filed by us.
At the time of disposal of the mandamus appeal
Yes.
on January 7, 2022, your name does not appear there. That shows that you did not appear in the said appeal.
This is Manjuli Chaudhary and Nikhla Singh.
It is not here, sir, madam. You are filing a review against an order, judgment dated January 7. Will you not look at the cost title where the appearance of the counsels are recorded? Don't you have a time to look at that? You are looking at your lawyer, the clerk. You do not have any responsibility as the advocate and record. Everything is dependent upon a clerk. Even your appearance is controlled by the clerk. Yes, but if she's there, that if she was here,
কেন ফাইলের উল্টো দিকে তো লিখে রাখে এগুলো ফাইলের উল্টো দিকে তো এগুলো নোট করে রাখে কবে
then we have to correct. If you were this, I try to work.
এগুলো লিখে রাখতে কি হয় একটা ডেট গুলো কোর্টের টাইম নষ্ট হয় শুধু শুধু মানে from the document details filed by the obtained from the computer section the wakalatnama by Mekla Sinha আমার দিকে দেখো wakalatnama filed by Mekla Sinha for district nodal officer and another on the 8th February 2023.
Correct.
It has been filed in the department.
No, sir, you know the procedure, the rules. if she was an advocate on record in a main matter, and if she files a review, then she did not have to put a separate wakalatnama for that.
Right.
Clear calls. But if somebody else have filed, then in that event, she has to obtain a no objection from the erstwhile advocate and then file a review. This cannot be done in this way. That's why I am putting a question to her, whether you were there in the MAT.
No,
It
she
so
was not.
happened that you have filed a wakalatnama, but you could not appear on the day when the matter was taken up.
Yes.
That we can condone. There is no difficulty. But you were there. But you were not there. She is unable to diverse. Every time when I ask a question, she is looking at her clerk. And the clerk is insisting and instructing something which is not appropriate in accordance with law, because he is not a legal man.
When the appeal was disposed of on the January 7, 2022.
Her name does not appear. There were only 3 appearances which is recorded.
That's right.
In a
My lord,
very,
for
very,
the
I would
respondent.
say the truncated manner,
Yes.
or in an ambiguous manner.
For the
One is
respondent,
for
sir,
writ petitioner, Mr. Kamalesh Bhattacharya, means he is representing Muhammad Azhar Hussain.
My lord.
Then for the respondent, Mr. Sanwar Jahan and Miss Mausumi Mitra.
There were several respondents.
Correct. So that's why I say ambiguous.
There were
I
several
put that question because of that.
Yes.
That whether you were engaged in the MAT or not.
Yes.
I was asking this question to her. She is unable to answer, looking at the clerk.
Didi Shilo. Didi was there. Didi is no longer here in this world.
Who?
Mrs. Chaudhary.
Yes, Mrs. Chaudhary.
Mrs. Manjuli Chaudhary.
She has expired. She has expired.
Thereafter, I have been appointed as lawyer.
Lordship,
in her
Now
case.
it appears that Miss Manjuri Chaudhary filed a review.
Yes.
Sure.
Yes.
I wanted this information from you. She was appointed in MAT. Are you sure? We will record this submission made by you.
Yes.
That the same the lady, the Miss Manjuri Chaudhary, was appointed as a counsel in MAT to represent the nodal officer.
Well, from the back sheet, I find Mrs. Manjuli Chaudhary was the advocate on record while the review application was filed.
Understand. I am asking whether she was also an advocate on record in MAT.
No.
I'm asking. She said no.
She was not. At least her name doesn't appear.
That is what I'm asking the information.
Yes.
Whether she was in the MAT.
ছিল কি নোডাল অফিসারের হয়ে ছিল কি Yes.
Then who was appointed as a counsel for nodal officer in MAT? Who was? Anybody was appointed or nobody was appointed? Tell us the fact.
সর্বজন সবাই জন্য ও তুই জানিস এটা
এই MAT রেকর্ডটা আছে
I am told, my lord, Mr. Bhattacharya is saying, my lord, that Sarwar Jahan was appearing for all the respondents in the MAT.
Mission director and nodal officer, he represents in all court.
yes.
Can we have the file of MAT?
Yes.
এই
তাই তো
MAT file এসছে? Oh no. Can you come at 2? In the meantime, we will bring the file of MAT.
Today, my lord, today at 2 p.m.
Yes.
My lord, I am late. Your lordship will kindly pardon me because the matter is fixed up before Justice Mukherjee, Omil Mukherjee at Tur. Omol.
It is better, my lord, to allow them and let the order be set aside because my client is in a deathbed. He is not even getting any single funding. He is a beggar now. In spite of order of court, allowing him to join in Somprosarok, vacancy is there, lordship division bench order is there. In this fashion, my lord, days in and days out, my lord, it is getting. He cannot survive, my lord. I cannot tell him that come on the next day. I have no
No, his presence is not required.
But his sufferance, my lord, is required to be seen by the honorable court. What level of sufferance he
If the Samprasarok appointment is given and salary be given, some payment be given, not allowed to join, no payment, absolutely zero status. Order was passed on 7th of January 22. We are in 24. Court's order will not be complied with. Keeping over everything, kindly look at the grounds. No ground has been made out, my lord, within the framework of Order 47. It is not, my lord, any order was passed behind the back of any of the respondents. It was a full-fledged hearing before your lordship's court.
Who, respondent number 2 to 4, who were there? The nodal officer was the respondent number, within the respondent number 2 to 4.
This appeal was filed by the nodal officer himself. Appeal was filed by the nodal officer.
No. Appeal
In the
was
matter
filed
of
by you.
Review is filed by the
No,
nodal
no.
officer.
The appeal was filed by you, and it appears from. Oh,
Review is
he
filed by
was the respondent number 2.
It is the review of the nodal officer.
I have seen. He is the respondent. Nodal officer is the respondent number 2.
Yes.
And somebody appeared, sir.
In the appeal.
At page 8.
Yes.
If you look at the first paragraph, it says, in the light of the same, there has been a vehement objection on behalf of the respondent number 2 to 4.
In
That
the
petitioner
judgment,
cannot be accommodated. 2 to 4, and a 2 is the district nodal officer.
Yes.
So somebody means the Sanvar Jahan must be appearing for respondent number 2 to 4.
3, my lord, 3.
Because there was an appearance. Even an argument was made on their behalf that there has been a serious allegation against the petitioner, and
Lord,
in
your
fact, the
lordship
petitioner
refers
was
to?
terminated from service from the post of the Samprasarak.
বটমের পাতাগুলো নাম্বারগুলো নিচের দিকে আছে স্যার নাম্বারের পাতা।
So I believe that somebody was representing the nodal officer. Now tell us, let us, when he is too emotional and sentimental, let us see the thing on merit. Yes, what is the ground for review? What are the grounds for review?
Yes. Memorandum of appeal to that.
Yes.
Yes. My lord, I will take your lordship to your lordship judgment. My lord, I shall be very brief, my lord. My lord, may I place the entire judgment, the factual aspect and everything? Perhaps it is not necessary. The question is, my lord, that this gentleman was appointed as a Samprosarok. He was appointed as a Mukko Samprosarok in a MSK.
Mukko Samprosarok in charge.
That is Mukko Samprosarok in charge.
In charge.
Samprosarok is one status.
And Mukko Samprosarok is another status.
Yes.
And in between is a Mukko Samprosarok in charge. Means he is to discharge the duties and responsibilities of Mukko Samprosarok until the regular appointment of Mukko Samprosarok comes.
Whether it was the stipulation in the appointment.
Yes.
It is a question. Well, to tell it very shortly, what is Samprosarok? That is, it is a primary teacher, as earlier known. What is Mukko Samprosarok? Head teacher. That is Mukko Samprosarok. Now, but Samprosarok and Mukko Samprosarok are two different status. Mukko Samprosarok is not a promotional post. It is not. Mukko Samprosarok is altogether a separate status and is being appointed by the appropriate authority under a different category. The duty of the Mukko Samprosarok is to look after the accounts and everything, as it happens in the case of the head teacher in our days. Now, unfortunately, in this MSK, the Mukko Samprosarok was there. He retired. No further appointment was made. But the account and the payments and all these things has to be done. Therefore, somebody else has to look after those business. Otherwise, the entire administrative part of the educational institution will be a collapsed one. So therefore, this gentleman was for the time being given in charge, Mukko Samprosarok in charge. Whether that appointment was correct or not, my lord, was not agitated in the appeal or even in the writ petition. But there were several writ petitions. The first writ petition, and even thereafter the succeeding writ petition, my lord, the respondent, that means this Azhar Hussain, the Samprosarok, was agitating the question that since I was given the appointment of Mukko Samprosarok in charge, I cannot be removed from that. He wanted to cling into that post, Mukko Samprosarok in charge. The first of which, my lord, in the writ petition, it was said that, well, the writ petition was disposed of with the observation, Justice Dipankar Dutta, as his lordship then was here in this court.
AIR 1997 Supreme Court 1005 was 1007. Yes, sir.
Yes. Should I, my lord?
Yes.
So, my lord, the Mukko Samprosarok in charge, even if he was not there, but in any event of the situation, his position as a Samprosarok has not been disturbed. But he was not happy. He again came up with another writ petition. Another writ petition also, very thing was confirmed. But it was said that since he was not being given charge of the Samprosarok, therefore, my lord Justice Sinha, in the writ petition before her, said it is a new cause of action, therefore you file a new writ petition. So he filed a new writ petition. In that writ petition, my lord, that writ petition, the judgment was that the observation of the trial judge was that, well, he has no status at all. Since he was removed from the post of the Mukko Samprosarok in charge, therefore, even the Samprosarok post also has gone. That is what. Against that, the appeal was there. In your lordship's appeal, the judgment. Now, in the judgment, my lord, we have ventured to come up with this review application.
What
as a
is your
stated, my lord.
grievance as a review?
Pardon, my lord, review. In the review application. In the review application, my lord,
We are doing the condonation. Remember, we are hearing the matter on merit.
yes. My lord, I will take your lordship, all right, from your lordship judgment at page 5. From page 5.
Yes.
Yeah. Yes. Subsequently, by memo number 199 dated July 2015, the service of the appellant as Mukho Samprasarok in charge of the said Madhyamik Shiksha Kendra was terminated with effect from August 2015, which was further challenged with effect from 1st August 2015, which was further challenged in applicant in WP number 2018 of 2015, though the said writ petition was ultimately dismissed, but with categorical observation that the service of the appellant as Samprasarok has not been disturbed. Yes, it is an admitted position. It was not disturbed. Then later, subsequently, next para, an application for passing an appropriate order was taken out in the said disposed of writ petition. It was contended that though it has been observed in the said order that the service of the petitioner as Samprasarok has not been disturbed, yet the petitioner has not been allowed to discharge his duty in such capacity. Means
Just
enough. I have referred to that. I've said that. I'm just going on. And then, my lord, a separate writ petition has to be filed, as I told. Justice Sinha. Yes. My lord, your lordship will kindly come to page 7. When the instant appeal was moved on February 4, 2021.
Just a paragraph before, because
before that, yes.
Just a paragraph before. The point which has been urged in the instant appeal is that the moment this court held that the service of the petitioner has not been disturbed, it should be. Even if the writ petition is dismissed, such portion of the order needs to be implemented with all rigor and force, and the petitioner should be permitted to discharge his duties as Samprasarok of the said MSK.
Yes.
It is further contended that the single bench erroneously observed that none of the orders have created any right in the petitioner to the post of a Samprasarok in the said MSK, and since there was a serious allegation against the petitioner, it does not deserve any merit. It is thus submitted that the petitioner may be permitted to discharge the duties as Samprasarok of the said MSK. Then it says, when the instant appeal, now you can proceed.
My lord, your lordship referred to page 7.
Yes, the earlier paragraph. You started with when the instant appeal.
Yes.
I read the just immediate preceding paragraph.
That's right.
Yes, then.
The immediate preceding paragraph, a point which has been
I have already read the entire paragraph.
The point which has been?
I just read it.
Yes.
So now you can continue with your paragraph.
Yes. No, but before that, my lord, one thing was there at page 5. At page 5, one thing is there.
It should be put into the same box.
ওটা হয়ে গেছে। না যতদিন বেঁচে থাকবে ততদিন। My lord, only one thing, my lord. I would beseech my lord, your lordship, to kindly look into that part at page 5 of your lordship judgment. Page 5.
Yes.
Page 5, paragraph starts with subsequently by memo.
Yes.
Towards the middle.
Yes, yes. That's the first
The
paragraph.
read court recorded. The read court recorded a specific finding. The appellant was well aware that he is not eligible to be appointed as Mukko Samprasarok in charge for lack of requisite qualification prescribed for such post. Okay. Ultimately, the prayer of the petitioner to remain in the post of Mukko Samprasarok in charge was turned down with a liberty.
Right.
With a liberty to make a substantive application for transfer if the occasion so arises. The said order has not been challenged and attained finality. That is the question. So therefore, my lord, one question was, my lord, it was being thought that the Mukko Samprasarok in charge is a promotional post, which is not.
Turned down, turned down.
But in your lordship judgment,
we have also turned down.
lordship will kindly pardon me, but in your lordship order, my lord, judgment, it has been reflected like that.
No. We have said that he has no right to act as a Mukko Samprasarok in charge, nor as a Mukko Samprasarok.
No, but in other context.
I have read the judgment by this time.
I will.
What we have held is,
that page 8.
That his right to discharge duties as Mukko Samprasarok in charge was absolutely found to be illegal. And all the writ petitions which was initiated by this gentleman turned into, I may say, in a futility, because he could not establish his right to act as a Mukko Samprasarok or Mukko Samprasarok in charge. The division bench, or even an earlier writ petition, it says that yes, as a Mukko Samprasarok you have no right, but as a Samprasarok your right has not been taken away. So the question that arose before us, and it was squeezed to only one point, was whether he is entitled to remain as a Samprasarok in the same MSK where he was discharging his duties as Samprasarok. Because that post or that right has not been taken away in any of the orders. So we say, it was argued on your behalf that there is no vacancy. We can't put you. We said that you can terminate a person as a Mukko Samprasarok. If you terminate that appointment or appointment is found to be illegal, does it mean that his appointment at the feeder post or appointment to a post just below that, which is absolutely valid, legal, and has not been challenged, that also automatically goes?
No.
That cannot.
It cannot.
So we say that no, his appointment as Samprasarok is saved. His appointment as Mukko Samprasarok goes.
Yes.
So he should be put as a Samprasarok in any MSK. The only point which was raised from your end was that there is no vacancy, we can't put it. We invited you to file a report or in the form of an affidavit. The affidavit says no vacancy. Then we said whether you have made any appointment. You said no appointment. We said you can't do it because this post of Samprasarok, which fell vacant because of his movement from a Samprasarok to Mukko Samprasarok in charge. What you have done with that post?
I'm not doing that. I'm not.
So we said that you put him. Ultimately, we have said that you put him anywhere in the MSK.
I'm not
as Samprasarok.
My lord, I am not harping on that point.
Yes. And then say that you create if necessary, how you have appointed, we don't know. And then we said that you create a supernumerary post to put him there.
So I have examined, my lord, the procedure for appointment. It is much more better than the...
His appointment is found to be legal and valid. That does not go.
Yes. He was appointed as a Samprasarok. And the terms and conditions of the appointment, my lord, is much more better than the learned judges of the High Court or the Supreme Court.
Is it?
Yes.
Is better.
The moment he is appointed, till date, he is Samprasaro.
So good.
Yes, good.
So why you say better?
And naturally, the unemployment problem will be solved.
No, you
that's
you
the
made a
difference.
comparison. That's why I was
I'm not
shocked.
on that.
Why you make a
I'm
comparison?
not on that. This is the rule that has been framed. Once you are appointed as a Samprasaro,
you remain as a
you
Samprasaro.
remain there. Yes. A very salutary rule.
The upper limit is 65 years. The notification is there.
No, I have admitted that.
No. Till death, you are saying no.
No, not till death. He has not said about till death. That's
You
what he
read
said.
that. Yes.
I never hear that till death.
No, I am. All right. I am not on that question. That well, he has a right to continue in the post of the Samprasaro. I believe, my lord, on this point, my lord, there is no debate from either from the side of the court or from his side. He is to continue.
But there is a debate from your side, no? Is there any debate from your side as a Samprasaro?
No. He is Samprasaro.
Correct. So appoint him as Samprasaro.
He was appointed as a Samprasaro.
He was. Now he is to be appointed.
Yes.
Yes.
No.
Yes, sir.
Yes. I am not on this point that well he has a right to continue as a Samprasaro.
Then what is the ground of review?
My lord, what I am submitting is, my lord, that this is a question that to which I referred to at page 5 of your lordship judgment.
Correct.
This was ultimately the prayer of the petitioner to remain in the post of Mukho Samprasaro in charge was turned down.
Correct. No difficulty.
With a liberty.
Correct.
To make a substantive application for transfer, if the occasion so arises.
Yes.
The said order has not been challenged and attained finally.
Correct.
I am keeping it in mind. Yes. Now, my lord, your lordship kindly goes to further.
Yes.
He made an application for transfer. That means he wanted to comply with the order. And your lordship was very pleased, my lord, to ask the authorities to find out a suitable place for his transfer. Now it was said that the transfer, there is no post.
There is no rule.
There is no rule. There is no rule of transfer. But even if no rule, but by virtue of an order of the court, it can be done.
Correct.
By virtue of the order of the court, it can be done.
That was a submission.
Yes. My lord, your lordship has said that.
Yes.
My lord, towards the end, my lord.
Yes.
Yes. Your lordship recorded that at page 9.
Yes.
At page 9.
Correct. We have said so.
Contention that there is no vacancy in any of the MSK within the district of Howrah is unfounded and untenable, as the director of the mission has taken a specific stand. Then since last 10 years, there has been no appointment in the post of Samprasaro in MSK within the state of West Bengal. Apart from the same, the contention of the respondent number 2 to 4 cannot be accepted so far as it relates to the ineligibility of the petitioner to the post of Samprasaro, for the simple reason that the authority never took such a stand and the affidavit filed today was restricted to the vacancy position of the Shikha Samprasarok in the MSK within the district of Howrah. The point which has not been taken by the authority shall not be permitted to be taken at the bar.
No, in the single.
My lord, question is this. The opposite proposition, then your lordship referred to a particular judgment.
Yes.
My lord, it is that. I'm not going to that. But then I am on page 11. Be that as it may, the right of the appellant to act as Shikha Samprasarik was recognized and crystallized in view of the judicial order passed by the court. But the authority is rigid, which can be reasonably visualized from the standpoint of the director of the mission. But the question is there. But the finality of the judgment has reached with that the applicant will try for a transfer. A transfer. Now, your lordship also wanted that this transfer, application for transfer be considered. But the application for transfer should be considered in respect of a post vacant in the district of Howrah. And for the last 10 years, there was no appointment in the post of the Samprasarok. Why? Because the post of Samprasarok, once the appointment is made, till the retirement period, my lord, of a particular age, perhaps it is there, no appointment can be made. So, my lord, I am just asking myself as to how I can satisfy the court that, well, there was no appointment and therefore there was no post available for his transfer. But the transfer he wanted on his own motion.
So that is what we have
Yes. Now,
we
my
have
lord,
said in that paragraph also.
yes. But in that paragraph,
if
your
there
lordship
are
has
several reliefs which are claimed in the writ petition, if the court found that one of the relief cannot be granted, there is no pressure on the part of the
My
court
lord.
to grant the other reliefs, because
Yes.
that has been done in this
Yes.
case.
My lord, my lord, in that case, my lord, an order which has become already an absolute and was not under a challenge. My lord, by a further order in a different appeal, in a different writ petition, and on a appeal coming out from that different writ petition, my lord, should an order be made like that or not?
Where is the difficulty? I do not find.
Should that order be altogether done away with, which has already, my lord, become a final one, an absolute one, without having an appeal pay for that, not even
What was that
referring
order?
that question.
With deepest of respect and humility in my command, what was that order? He was all along insisting and harping upon his appointment as a Mukha Samprasarak, either in charge, as an in charge, or in a regular post of Mukha Samprasarak. So the court says that you can't, because you are correct, because there is a different route for appointment of a Mukha Samprasarak. The Samprasarak post is not a feeder post of a Mukha Samprasarak. It is absolutely an independent post, and two different, I would say, the criteria for appointment is there, or a different mode of selection is also there. So you are correct. So he can't do it. But the court has said in one of the matters, while I would say discarding his contention that Mukha Samprasarak, court says you were a Samprasarak. At least that post has not been, your service has not been disturbed.
I'm not disputing that.
As a Samprasarak, it is not disturbed. But I can't give you a relief as a Mukha Samprasarak. Then later on he came and wanted to assert that my right as a Samprasarak, which has already been crystallized, which has already been recognized, that right must be given to me. You are denying that right as well. Can he not maintain a proceeding to assert that right?
My lord, we have not.
That
With
is
deep
what he has
respect,
done.
We have not. Because, my lord, when his position as a Samprasarak,
that is what I'm saying. Yes.
He is not disturbing, he is reminding me that it is 1:15.
Not only that, now the leader.
I don't say this.
president post he is contesting, so cadets are calling him. I find from the board. So must be relieved. Must be relieved.
Did I say it to you, Lordship?
No, I said.
So
When it has started?
tomorrow,
Campaigning last week. Even last week campaigning started.
No. The date.
29th.
That whole week.
my lord,
29
Crucial time. Crucial time for the candidates.
No. He has more, I would say, responsibility towards the client than the
it will be denial of fundamental right.
Actually, but excluding this period.
But he is not allowing me to discharge my responsibility. Right from the last 10 minutes, he is saying, go, go, go. He has a business here. He has a business here.
No, you continue. We want to discuss it.
Now,
No. Duto samay.
my lord, 2 o'clock I am already fixed, my lord. It is because of me. It can be fixed up tomorrow, my lord.
Let me at 3 o'clock, my lord.
No, because on a question of limitation, my lord.
No. Well, don't worry about it, because so far as the section 5 he has very candidly and fairly said.
You know, whether section 5 is necessary at all.
Which one? We are disposing of the section. Why not
Allowing you.
necessary?
Delay no.
Why not necessary, sir?
Pardon, my lord?
Why not necessary? Why you say section 5 is necessary?
2008 1 CHN 442.
What it says?
It was said, my lord, that since it is a writ appeal, in a writ appeal, my lord, the Civil Procedure Code Order 47 will not apply.
I have a different view.
One, it is a division bench judgment
I
of
have
your
a
lordship.
different view on that. Right from the Supreme Court's view.
All right.
I have a different view. I will substitute one judgment which says
That's
no
what
longer
said.
a good law.
Well, it was on reliance upon a Supreme Court judgment, my lord, that was delivered. However, my lord, I am not disputing that.
Anyhow, he has conceded.
But however, I have
for
given.
the concession. That's why we asked.
Even then, my lord, I have filed my application for section.
Anyhow, we will allow. Anyhow.
So, my lord, tomorrow at
judgment, when you are arguing, we are giving you an advance notice. AIR 1997 Supreme Court, page 1005.
Yes.
Write down.
Delhi now.
Write down. AIR 1997 Supreme Court, page 1005. Mr. Bhattacharya may be happy. It's for you.
1705.
100.
AIR 1998.
No, 97.
97.
Go to 1005.
Before
You can have a privilege of book during the recess.
Before Milo dies.
1005.
My lord, tomorrow at 2.
At first. Don't worry. At 10:30.
Well, 34 intimate expiring today. It doesn't mention, my lord. The lordship was pleased to fix it 2 p.m. Both of us, my lord, at 2 p.m. we have the fixed matter, the same matter.
Where?
Long 5:36 or something like that. I think 52. Kindly extend the interim order and fix any day it suits lordship.
It is continuing.
No, not this matter. 234. It was mentioned.
Continuing in the list. The
No,
matter is
interim order
continuing
expiring
in the
today.
list.
Expiring today.
So it will remain in the list, what it says.
Well,
I can assure
kindly-
you nothing done, my lord. We will
Yeah.
extend it, my lord.
Extend হলে ভালো হয়তো দুজনেরই কি মুশকিল if it is extended both will be benefit
It's a hardening part though. My lord, hardening.
Principally,
Otherwise, it will not be beneficial for us.
it will be. Hey, এটা record করে দাও.
234 টা
Record.
interim order.
This is an application for condonation of delay in filing the instant review application.
Well, okay.
Benefit, naturally, it must be beneficial.
The respective councils and perusing the amendments made in the same application, we are satisfied that the minister was prevented by a sufficient cost.
It's a product.
Not filing the review application within the statutory period of limitation provided therefore. Come on. The application is allowed, the delay in filing the review application is condoned. We invited the attention of the respective councils to address on the merit of the review application.
Productive bolo.
Let this matter be listed tomorrow in the same category to be taken up at 10:30. Now, beneficial for both of you?
Now can it benefit us?
Regarding to
234 34 তো
34, my lord, I got it. One of 4 and 5, my lord.
both the councils uniformly submits that the interim order granted in the instant matter is expiring today. There is no possibility of taking this matter today. In view of the above, let the interim order granted earlier be extended for a period of 3 weeks from date or until further.
Let it be in the list. It will not taken up.
Let the matter remain.
Yes, yes.
It will remain.
Yes.
Sure.
This call, Malad, in the morning, mentioned item number 116. I have some notice.
Malad, I am appearing for the appellant.
What will you mention? Malad, on 17th May 2023, Honorable Justice Trumanson and Honorable Justice Uday Kumar were pleased to direct the parties to file a mutual divorce application before the court below at Bankura, which has already been filed, and for welfare and maintenance of the child. The sum of rupees 30 lakhs was directed to be paid, out of which 15 lakhs have been paid, and the remaining 15 lakhs is ready, my lord. But the only thing is that the learned source widow is awaiting for the order from the honorable court since the appeal is pending, my lord. And mutual divorce petition has already been filed, my lord.
You're talking about which order?
My lord, on 17th May 2023.
17th May
2023 May.
Is it 17th May or April?
17th May 2023. Well, this is the copy of the order.
File থাকবে তো ফাইলে আছে
April, no? Oh, April. Oh, 17th.
আমাদের লেখা নেই কিছু সেগুলো কত ফাইলটা
15 lakhs through RTGS or NEFT has been done?
Yes, yes, ma'am.
the first installment has been paid and the second installment is ready. So
You will have you filed a 13B application?
My lord.
but the case number is
13B is on 4th January, the date was fixed before the trial court, my lord. Since the family court has been set up in Bankura district, my lord, the file has been sent to my lord family court, but the judge was on leave. That's
For the state respondent, your lordships, in this matter, 290, your lordship, I am appearing on behalf of the state respondent. Let Mr. Tapan Kumar Mukherjee, Mr. as instructed by me, not this week.
Why?
Because travel, some difficulties not come to the court this week.
But not this week.
Not something.
My lord, I am appearing for the review.
Yes.
My lord, I am for the applicant, my lord.
For the respondent.
My lord, this is
Led by Mr.
Whose
Abrotosh.
order?
my lord, review of your lordship's order
Sitting with?
my lord Justice Shamanto, my lord, as his lordship.
Well, I'm for the respondent led by Mr. Abrotosh Majumdar in this planet.
My lord,
What is this?
my lord, in this matter, your lordship by an order dated 8th February 2023 directed the parties to file affidavit in opposition in connection with the review application.
I am talking about what is the order which is passed.
My lord, yes. My lord, this is, my lord, your lordship kindly consider page 10 of the memorandum of review. This is a judgment and order dated 11th May 2022. My lord, in this, the
Review. 10C to be.
Stop it.
Yes.
But here, my lord, some teachers of a particular school, my lord, moved a writ petition before the applicant, before your lordship, who is the assistant headmistress. Now, my lord, she was demoted to the post of from the post of assistant headmistress to assistant teacher. Now, my lord, she preferred an appeal challenging that order. She was now your lordship, my lord, set aside that order of demotion, saying that this is a punishment. That was issue number one. Second issue was, my lord, your lordship also quashed the order of transfer, saying that this is not a sanctioned post. Now, my lord, subsequently, my lord, we found that this was a sanctioned post. This is a sanctioned post. That is why state, my lord, state's affidavit is relevant.
Yes.
Your lordship kindly consider page 21 of the judgment. Page 21 of the.
Was this fact taken on record? Have you stated anywhere in the record that this is a sanctioned post?
Well, this
anywhere in the MAT or a writ petition?
Well, writ petition was filed by the teachers. I was the respondent.
Right. Did you file any opposition? Did you take that plea
Well,
that it is a sanctioned post? Did you take anything?
Well, on the very first day, the writ
it is a
petition was
sanctioned
disposed of.
post?
On the
It
very
is a
first day.
sanctioned post?
On the very first day, my lord, the writ petition was disposed of. I was.
Whatever. Then in the appeal, when you filed a stay application, can one, did you disclose that?
My lord, when the appeal was taken up, my lord, I had.
Sir, why we are asking this question is error apparent on the face of the record. If the record is silent, then whether it can be termed to be an error apparent on the face of the record. I am just simply asking you this question.
My lord, that when the judgment was delivered, my lord, there are two things. First thing is, my lord, it was the duty on the part of the state respondents, or the DI particularly, my lord, to indicate that
why it was a duty. When you can come with the fact that it is a sanctioned post, then you could have disclosed this at that point of time.
My lord, the authority transferred me in terms of, my lord, section 10C of the relevant provision.
Correct.
Now, my lord, has to be presumed that this is a sanctioned post. Now, it is the duty of the state, my lord, to indicate that whether this is a sanctioned post or not, because my lord, unless it is a sanctioned post, my lord, the question of transfer cannot arise.
No, you are appointed
My lord, I am an
as a permanent teacher. You were appointed as a permanent teacher. If any transfer is effected, obviously it has to be. But if they have taken a decision, they will pay you all the benefits attributable to your service as a permanent.
my lord, transfer is permissible, my lord, under section 10C. Question is the post is a sanctioned or not. Your lordship, my lord,
That was not.
my lord, your lordship kindly
Nothing.
consider, my lord, page 21 of the memo of review. There are two issues.
Show us from the judgment that where that has gone wrong. We are not concerned with your memo. We are concerned with the error which you perceived from
Yes.
the judgment. Show
Very
us.
well. Very well.
Show us.
My lord, your lordship kindly. My lord, kindly consider page 15 of the review application.
Sorry? I am talking about the judgment.
Yes, yes.
Internal page at the top right hand side, you will find the page. Tell us which page.
Yes.
Internal page
My lord, kindly consider page 21 once.
of the internal page 21. Yes.
21, no,
It's
I'm
only
sorry.
the quotation.
21 of
Not
the, in 21 of the memo of review, my lord, that
We will not
internal
go
page 12.
into memo of review.
Yes.
We wanted you point out from the judgment. You sought for a review. Please tell us that where according to you is error. Tell me.
My lord, your lordship kindly consider internal page 12. The issue framed by your lordship. Yes.
Please to us. Yes. Firstly, whether the recommendation of the West Bengal Central School Service Commission and approval by the DIE
Proposing a transfer.
of assistant headmistress is legally sustainable
If the same is not.
against the sanction post. One.
Second.
Secondly, whether the writ court can usurp the power of the authorities under the relevant rules and pass an order inflicting the punishment which is not contemplated in a disciplinary rule, or whether the court can impose a punishment dehodes the procedures and norms provided in the statutory rule, substituting itself with the disciplinary authority by ignoring the application.
My lord, so far the issue number 2 is concerned, my lord, your lordship held in my favor. Your lordship, my lord, set aside that portion. So far this one is concerned, my lord, that whether the recommendation of the West Bengal Central School Service Commission and approval by the DIE of schools proposing a transfer of an assistant headmistress is legally sustainable if the same is not against a sanctioned post. My lord, that went against me. Now, my lord, I found, my lord, subsequently, my lord, that this is a sanctioned post. Immediately there.
Can a review on a subsequent event or on a suspicious, just tell us that how you have disclosed it, how you got it.
Yes, my lord, your lordship kindly.
And can you satisfy that particular due diligence concept?
Yes. Yes, my lord. My lord, these documents, my lord, what I have.
We have said that it's not a sanction. So tell us, show us that.
My lord, your lordship kindly. My lord,
show us.
Yes, my lord, your lordship kindly consider my supplementary affidavit, my lord, which was filed, my lord, pursuant to.
Supplementing you are supplementing.
My lord, I have annexed those documents.
Simply asking, sir, are you not understanding the expressions which you are
Yes,
using?
my lord, I have annexed those documents.
Either we are unable to percolate what we really wanted from you, or you are consciously avoiding to understand.
Your lordship kindly consider page 71 of the supplementary affidavit.
I am asking you from the judgment, sir. You are
from the judgment. I'm sorry. I'm sorry.
The judgment.
I'm sorry.
Will you not point out from that judgment that what this court has held?
Very
and
well.
According to you, there it is either wrong or it is correct. What is your grievance to this? Then we will go.
My lord, your lordship kindly consider internal page 16 of the judgment.
Please tell us that which portion, where, what the court has held. Tell us first.
My lord, there are 2-3 paragraphs. Kindly consider page 16 first.
Yes, which paragraph you wanted to rely?
My lord, second paragraph.
Yes, paragraph 3 thereof contemplates.
Yes.
Yes.
The permission of the selection committee with its constituents and the exhaustive provision concerning the suitability of candidate for such post subsequently by memo number such and such dated 19th May 2004 was issued by the School Education Department, Secondary Branch, Government of West Bengal, indicating the necessity of appointment of the assistant headmasters or assistant headmistress in high school, high madrasa and higher secondary school and or higher secondary madrasa where the roll strength exceeds 700 or above and 1000 or above respectively for 3 consecutive years. It was further indicated that the creation of such post in any school shall have to be approved by Director of School Education, which has been redesignated as the Commissioner of School Education.
Yes.
My lord, thereafter, my lord, your lordship kindly.
So where is the wrong?
No, my lord, this is one of the precondition that the schools, the strength of the school should be 1000, my lord. I shall.
This is what. Yes. Then
thereafter, my lord, your lordship kindly consider. My lord, your lordship kindly give me a minute's time, my lord. Yes. My lord, internal page 17, my lord. The sentence starts with, my lord, in the middle, the conjoint reading. On the left-hand side, the conjoint reading of the aforesaid provisions as enumerated herein above leaves no ambiguity that the assistant headmasters or assistant headmistress can be appointed in a school from the willing teachers of the said institution, provided the post is sanctioned by the competent authorities, subject, however, to the fulfillment of eligibility criteria enshrined therein. Section 10C of the Act of 1997 brought subsequently conveys the manifest intention of the legislature that such category of persons can be transferred to any other school in the interest of education and or public against sanctioned post. Now, this is one. Your lordship kindly consider thereafter page 32.
Yes.
My lord, third line, the sentence starts with the harmonious reading. The harmonious reading of the provisions.
Page 30.
Internal page 18. I'm sorry. Internal page 18. I'm very sorry. Very sorry.
Yes.
My lord, third line sentence starts with the harmonious reading.
Yes. Yes.
The harmonious reading of the provisions contained in the Act, rules, and the memo issued from time to time by the competent authority exposes the legislative intention that though the transfer can be effected from one school to another, but against the sanctioned post, and therefore any order of transfer which contravenes the statutory provisions or the mandate of law, if challenged, should not receive the sanction of the court or its blessing solely on the ground of locus. The powers of the writ court cannot be understood to give sanction to the action of the statutory authorities, but to bring within the precincts of law. Whenever the injustice is found, such injustice cannot get away solely on the ground of locus. In the instant case, it is not in dispute that there was no sanctioned post of assistant headmistress in Kamala Vidya Mandir High School for girls, and therefore such transfer is contrary to Section 10C of the West Bengal School Service Commission Act 1997.
True.
This is your lordship's finding. The memo dated 19th May 2004 is expressly in the sense that such post cannot be created nor any appointment can be made if the roll strength as indicated therein is abysmally low. It appears from the pleading that the roll strength of the school is abysmally low, nor there is any document is coming before us that the Commissioner of the School Education has sanctioned and approved the post of assistant headmasters previously. If the law requires such transfer to any sanctioned post, merely by issuing an order of transfer, such post cannot be presumed to have been created and or approved by the Commissioner of School Education being the competent authority in this regard. We thus have no hesitation to hold that order of transfer issued in favor of the appellant is per se illegal and contrary to the provisions of law and is therefore quashed and set aside. The question number 1 is answered accordingly.
So
now, my lord.
So no, where is the difficulty?
No, difficulty, my lord, is only
So
one
we have
thing.
very, very vividly and
Yes.
explicitly
Yes.
said that if the transfer is to be effected, it is to be effected against the sanctioned post.
Yes. There is no doubt. But my lord, that point, my lord, has not.
Sanctioned post to depend upon the number of the student roll strength.
No, My lord, that is not now, that number of students is not relevant. Only thing is, my lord, whether the post is a sanctioned one or not. That is a precondition.
We say that Kamala, this Vidyalaya does not have a sanctioned post of the
My lord, that is contrary to records, my lord. That is contrary to records. With deepest of respect.
Where is the record?
Yes, my lord, your lordship kindly.
You disclose that?
Yes.
Because
My lord, kindly
every case
consider.
was on that.
Yes, your lordship kindly consider my review application, page 52. Page 52 of my review application. My lord, when I filed this review petition, my lord,
No, that is sanction. There was a sanction. Which was never put on the government who is coming up. Because you are happy to do it. You might say, sanction is to which you get it. Even that's true. Such transfer should be strict. Agency, that's all. Yes. Memo dated. Since she has already joined the school where she has been transferred and is discharging the function. So maybe she may be directed to revert back to her original school within 2 weeks from date. Both without saying that I was not at fault when the order of transfer was issued, and therefore all benefits which she received at the transfer board shall not be to them. Because she was not at fault. That's why we say so correct. Where is a school service commission act? Where is that? Show us, because my brother wanted to see that because it's the state legislation. That's why I interpret it. This one must be necessary. It's very clear fault. Set aside the order. Sanction proceeded supplementary application বলেছিলাম
The application আমরা বলেছি
There, the teacher has to apply for transfer. Let's see what it is. So, one can transfer. The retaining is a mutual, 10B is on application, and that 10C is done.
My lord, may I just, my lord, indicate one circular, my lord, of the school education department in exercise of section 10C. My lord, in 2018, my lord, the school education department decided to transfer any teacher, including the headmaster or headmistress or assistant headmaster or headmistress to any school. Yes. The only precondition is, my lord, the post has to be a sanctioned part.
This is what the language of
Yes,
10C.
yes.
Where
Therefore, my lord,
we have
this-
also held that it has to be transferred against a sanctioned post.
Sanctioned post, yes.
So that
Yes.
is what we also held.
Yes. Now, only one thing, my lord, I just indicate, my lord, subject to your lordship, kind correction, my lord, because my learned senior friend has taken a point of this role strength of that school. Now, this circular says notwithstanding anything contained in anywhere. Therefore, my lord, that was a circular of 2004. In 2018 circular, my lord, it says only precondition would be the sanctioned post, nothing else. That is why I'm just indicating this circular. Otherwise, not relevant, my lord. I'm led by Mr. Banerjee, my lord. If your lordship
But
can-
apart from that, what he's saying, see, dropout is a phenomenon in all over the country. Dropping out of the students. Let's assume there is a sanction post. Let's assume a figure that if there is a 200 students are there on the physics, then there would be one sanction post. Right? A person has been appointed. Number of dropping out is there. It has dropped up 100. The natural consequence would be what? The sanction post would be scrapped? Certainly not. When the post would be sanctioned, that is depending upon the strength on that date. Number of students, etc. That is, it is within the domain of the authority. Once a post is sanctioned, then whether the students are there or not there, for that reason, it cannot be said to be that he cannot be appointed, he cannot remain unless a view is taken by an authority. That's a discretion of them. That's also not the matter of this court. Therefore, the circular which was shown by my learned friend, that
it was a matter of this court at one point.
Your lordships have heard it, this matter. I was arguing this matter, lordship.
No, you say this is not a matter here. I said this matter was there at one point of time. The gentleman sitting behind you was arguing vociferous.
No, he's and he's
behind.
Oh, they great Kolol Bose. But he says that he says always to us
because they challenge the virus of 10C.
What he says normally lighter note.
Yes,
outside the court, there is one Netaji Bose, Subhash Chandra Bose, then Jyoti Bosu, then Kolol Bosu. That's the great. He is always great, Miller. But what was happened in this matter? What was happened in this matter when the matter was being heard, Miller? The state did not place the document that it was a sanctioned post
at Kamala with the
Kamala. It was a sanctioned post, and
we held that there is no sanctioned post in Kamala.
Your lordships held it because no document was placed before the lordships. That's the reason your lordships has held it. That's the reason we have come up with the review. That factual, Miller, that
what is your explanation on due diligence? Because there are with very limited ground of
understand,
review.
Miller, but
error of the error apparent on the face of the record, then discovery of new and important document, which despite due diligence was not within your knowledge and you could not. So we can definitely go in this aspect because your junior was saying that subsequently we got
it. This document is starting by 18 May 2004, no doubt about it. We had
No,
no
it has
knowledge.
to be in existence prior
In
thereto.
existence. This is there.
Only explanation of due diligence. I just wanted to
I
know
would
that.
have said in paragraph 5
Of
of the review application.
review application.
No.
Stay application or review application?
Review, my lord.
I do not find the review application.
Is numbered. Can one in review RBW 81 of 2022.
It is captioned as the stay of the operation of the judgment.
Total stay of operation of the judgment reaches. I am
presentation form.
Must be you have sent it to the clerks.
Anyhow, which paragraph?
No, a matter. I have to. Really, this is very technical. I am arguing for 2 days before one of the single judge, simply because junior has not taken care of, and going on the basis of the clerk's knowledge, filing is there. Point is nothing. Commercial division. It is when written original jurisdiction. It should be commercial division. That's going on that, arguing for 2 days.
Anyhow,
kindly come to paragraph 4 and paragraph
4.
But this was of course of the obligation on the part of the state respondent to say. Failed to indicate that.
Anyhow, oh, you have said paragraph 5. Due diligence has been used.
But that is only after the.
Where is that document?
Document is at page 52 here. Page 52. We have given the document. Page 52. Kindly see
application
in the Kamala Vidyalaya High School of so-and-so, sanction post in normal so-and-so, category of the post HM, and nature of vacancy permanent.
Assistant headmistress.
Assistant headmistress. That time someone was there.
Where, yes, how they have reacted to it in their opposition? Have they filed?
State has filed an affidavit. State has not filed any affidavit, my lord.
No, there is, I find a reply and all, everything.
That's
my
lord.
We have filed opposition. Well, we have filed.
Where is that?
Let the affidavit, other affidavit.
We have
Oh,
filed.
yes, affidavit in opposition on behalf of the respondent, writ petitioner.
Yes, ma'am.
Sudeshna Kaur.
Yes.
That is fair. No, the state has not said so. This point never arose because.
Lord, kindly come to his affidavit. He is relying upon.
The issue was this.
19 May to the kindly come to paragraph 8. I say the judgment delivered in every was just
Based upon the paper. 1 minute.
Okay.
Yes. The transfer is made and the transfer is paid as an assisting editor. So she held the post of an assistant headmistress, which is at the time of argument, the notification of issued which postulates that the transfers have only been effected against a sanctioned post. And the post on which the transfer is recommended shall be of the same category of the pay and medium and structure and the teaching. We relied upon that.
You can say that another school does not have the sanction post of an assistant headmaster. State has come. Let us see. See when they got yes, state affect page 18. Spaces of that school. In terms of the president of the list, we should have sent the transfer order to the session, transferring the from garden within body to Salem. But subsequent to this order, transfer order was cancelled. Transfer to the project school is a common identity. Transfer to as assistant. As assistant, it further transferred to the central school commission also recommended the transfer of to the state school, which is very from the document next to the application. In compliance of the order of transfer, we have joined the present school on system. In the meantime, the joint secretary informed the that her absence had been recognized, same as this winter. The school director to the teacher in charge as the headmistress of the system to the existing. As it was the student approved by the Further surveys the tendency of the census provides for a transfer on two incomes. Firstly, in the interest of education, it's an interest rate. Such transfer from one school to another should be made in this section. We further relied upon a memo issued by the department in support of the district and only issued by a teaching committee. Teaching, however, to the action of such according to the interest cannot be the strictest, then he says that this is the school is far below the benchmark, and therefore such appointment is contrary to the. To conclude, you have not wisdom. Specifically, there is no sanction for the system. This is what is it happens. So this was his there is no sanction. Now tell us where is that memo of page 50? You were referring this page 52. 52.
And page 52.
Now, how he has reacted in the opposition?
No,
the state.
He has, my lord, what he has said, my lord, kindly paragraph 10.
Yes.
In view of the I respectfully submit the even disclosure of memo number 8
paragraph
10.
10. Yes.
In view of the above, I respectfully submit that even disclosure of memo number 847 M dated 18 May 2004 would not have altered the status of the applicant nor could have convinced the Honorable Division as regards the alleged entitlement of the appellant to be appointed and to remain in the relevant post. I say that in the review of this, no case has always transferred. This is his case. What is his case? Kindly see, Millard, his case is at page 21, kindly come to page 21 of his affidavit.
Opposition.
Opposition. I placed his opposition at page 21. He is relying upon this 19 May 2004 circular.
Yes.
This is third paragraph. No assistant headmaster stroke headmistress should be appointed in a class 10 class school higher unless the roll strength exceeds 750 or above for 3 consecutive years, and for higher secondary institution including madrasa and with higher secondary courses unless the roll strength exceeds 1000 or above. This is his case. 18 May 2004 order, the post has been sanctioned, that I have shown to your lordship from page 52 of my stay petition. Sorry, review application. Review application, page 52 of the review application.
Yes.
And other documents are there also in the supplementary affidavit filed by us. That's at page supplementary affidavit. 71 to 70. Permanent post permanent other documents, lordships have given us the leave to file a supplementary affidavit. We file it. Kindly take me supplementary affidavit, page 72, 72, 72, 73, and 74. All that will establish is a permanent post.
This is of 88.
88.
Yes.
18 May 2004. Then this continuous some documents.
This is the appointment of one Pratima Majumdar.
A post created. Post. Kindly say post.
Created by the Education Department. 77.
12th August 77.
And 73 is the same document as page 52.
Correct.
And this is the 2005 document.
2005 document. The post was created long back.
Yes.
Post created was long back. But he is relying upon 2004 circular, which is I have already shown to you lordships from the affidavit in opposition filed by him at page 21.
Yes.
Right, now my junior has already placed your lordships the circular dated 12 March 2018 now. Kindly see, even today's law, what is the today's position is this? See, whether 2004 circular doesn't exist at all here now. Kindly see. In exercise of the power conferred under section 10C of the West Bengal Service Commission, read with substance to Sector Board, the following guidelines are hereby in respect of transfer of teaching and non-teaching employees of government sponsored and aided school in the state and notwithstanding anything content elsewhere. The Department of School Education may, in the interest of education, in the interest of publicity for administrative, direct the West Bengal Central Commission to make recommend pressing the service of any teacher, including headmaster, transfer assistant, or non-teaching staff into librarian one school or to another school against any sanctioned post.
This is what a section 10C.
Correct, exactly. They are notwithstanding anything content. Therefore, 2004 circular, which is relied upon, which is being relied upon by him, it has no consequence. And more particularly, kindly see the Clause 6, such transfers shall be made only against sanctioned post. Therefore, my lord was, since at the time of hearing of this application and appeal, my lord, we could not, nobody, my lord, it was the responsibility of the state to place before the lordships that it was a sanctioned post. Your lordships have held it that since it was not a sanctioned post, I should not remain there. Therefore, if it is a sanctioned post, I should remain there until, my lord, they decides to take a transfer. That's a administrative decision I have. That's a different part altogether.
Yes.
And just to inform your lordships, although it is not in the review of the stay petition, is there, just to inform to the court that, my lord, after your lordships have passed the order and given, my lord, certain times that within this date it has to be done, if they should do it. Prior to expiration of that, they moved to another writ petition before the learned single judge.
Who?
My learned friends clients. That I should not be given the post of the teacher in charge, etc., etc. Well, that was challenged in an appeal. And I should be transferred. I should not work there. Before the time given by your lordships in that, prior to that, you moved and single judge passed the order. That order was stayed by your lordships initially on 19 January 2023. Right? 19 January. Sorry, 20th May 2020. 22. Then time to time it is extended. Ultimately, my lord, this appeal was disposed of by the another division presided over by Justice Talukdar, that since we are in the order will be status could continue until the review application is heard by your lordships. Therefore, my position is this today, that I am still working as an assistant headmistress there by reason of the order passed by initially by the division bench presided over by my lord Justice Tandon, then which was been confirmed to the extent that until the review application is there, for your lordship's information, so that nobody said I have not said the correct thing. Although that's not a very material facts for the determination of the review application is. This is point. This is the point. Point.
My lord, will kindly take the supplementary affidavit filed by the, I'm sorry.
You're appearing for.
My lord, the first respondent, writ petitioner respondent.
Means.
And all the teaching staff of my lord this school.
Review is filed by some Songamitra
Yes.
Bhattacharya. She was writ petitioner.
No, she wasn't the writ petitioner. My lord, we were the writ petitioners.
Means
several
persons.
Several persons.
Sudeshna from
God
Sudeshna
and all.
and all
Yes,
everything,
yes,
you
yes.
were the writ petitioner.
Yes.
And what was the scope of the writ petition challenging that order of transfer?
No, my lord, challenging that order of transfer, and also, my lord, the inaction on the part of the board in paying heed to the grievances registered by us against this assistant headmistress.
Oh, you were against the assistant headmistress.
Right.
And you are in the same school.
Right.
As the teaching and non-teaching staff.
Right. My teaching staff, mostly the teaching staff. The petitioners before lordship are all teachers. Only one non-teaching staff is there.
Yes. So, what is your reaction to this
review? My lord, kindly take. That is why kindly take, my lord, first the supplementary affidavit filed by the review petitioner, the review applicant. Kindly take from page 71.
Yes.
First is, my lord, this is dated August
77.
77, where, my lord, the post of assistant headmistress was sanctioned for a period of 2 years with effect from 1st of March 1977.
It is what is this? It's temporarily.
Temporarily for 2 years with effect from 1st March 77 within the sanctioned strength of teaching staff of the school. The post of the second clerk, that is not relevant. Then, my lord, comes the next order. Kindly take, this is 2nd of March 88.
Yes.
Lordship will find the services of one lady, namely Pratima Majumdar, were approved as assistant headmistress, and it refers to a nature of vacancy post created by the education department by its memo dated so and so.
So that is at page 77.
70
71.
72. First
72 is the reflection of 71.
72 is reflection of
71.
71. Absolutely. I'm sorry.
Yes.
Yes. My lord, kindly take, my lord, this one. This is, my lord, basically the sheet anchor of the case made out by the review petitioner in the review application.
Correct.
But this is page 73.
Yes.
But may I read it out? The secretary headmistress so and so, prior permission to appoint headmaster, headmistress, assistant headmistress, assistant teacher so and so, school's memo number so and so, dated April 30, 2004. Permission is hereby accorded to appoint the following staff in the school with the sanctioned strength. Well, at that stage, well, kindly note the date. The date of this memo.
18/5/2004.
The date is extremely relevant. So, my lord, at that stage, as on 18th May 2004, my lord, it was the only consideration for appointment to the post of assistant headmistress was, my lord, availability of a sanctioned strength.
Yes.
So, my lord, in that context, as on that date, my lord, this memorandum was issued, and your lordship will kindly take column number 3. Much emphasis has been supplied to column number 3.
What about column number 1?
Column number 1 is NS section.
What does it
HS section. I'm sorry, HS section.
HS. Okay.
HS section.
Okay. I heard it NS.
I also thought it is NS, man.
Yes.
But it is HS
So
section.
I was thinking of normal sanction.
No, man, it's not. No, it's a higher secondary section, my lord. Your lordship will find, kindly take, it will be apparent that না এটা কি normal section না HS section? না, normal section. ওটা জিজ্ঞেস করো তো। না, normal লেখা আছে এখানে।
Sanction post in normal.
I think it is normal section. Your lordship is absolutely right. My lord, NS section. Now, my lord, kindly take the post is AHM.
Yes.
The nature of AHM, assistant headmistress. The nature of vacancy, normal or additional permanent. It says permanent. Cause of vacancy is the death of one Pratibha Sarbogya who died. Then qualification, it is noted. Then, my lord, mode of seeking candidates, second stage, third stage, among the approved teaching staff as per government rule. My lord, at that stage, my lord, there was a 2002 guidelines which were in force, which required that AHM is to be appointed from the approved teaching staff of the relevant institution itself. But because there was no 10C at that stage. Now, my lord, kindly come, this is 18th May 2004. My lord, then kindly take my affidavit.
Page 51, 19th May, 1 day just after.
My lord, there has been a slight kind of paradigm shift. The shift is from sanctioned strength to role strength. It is no longer sanctioned strength which is relevant. It is the role strength which is relevant. Kindly take my affidavit.
Page 21.
Page 21. Well, I've dealt with the submissions, the averments of the review petitioner at paragraph 37 of my affidavit in opposition. May I read out this page 21?
Yes.
This is addressed to the director. This is from the school education department. This is a circular. This is the proposal for fixing up of the norms for entitlement of sanction of assistant headmaster, headmistress in a recognized non-government high madrasa and HS institution. Now may I read it out? With reference to the above noted subject, the undersigned is directed to invite his attention to the government orders dated 24 December 1966 and 30th April 1968 wherein it is clearly specified that no assistant headmaster or assistant headmistress should be appointed in a higher secondary school or a high school including madrasa unless the roll strength exceeds 400 or 300 respectively. In continuation and partial modification of the aforesaid government orders, fixing up the norms for entitlement for sanction of assistant headmaster, assistant headmistress in a recognized non-government secondary and higher secondary institutions, including madrasa, the undersigned is directed by the order of the governor to say that the undersigned
Under the changed
under the changed circumstances arising out of gradual increase of enrollment in schools, the government in the school education department has agreed to the partial amendments in this regard in the following manner. No assistant headmaster or headmistress should be appointed in a class 10 high or high madrasa unless the roll strength exceeds 750 or above for 3 consecutive years, and for higher secondary institutions including madrasa and higher secondary courses unless the roll strength exceeds 1000 or above for 3 consecutive years. Well, one fact is undisputed. It cannot be disputed. The fact which is cannot be disputed is that as on date, the roll strength of the school, or when this order was made under section 10C of the Act, the roll strength of the school was much below the required roll strength as provided for in this office memorandum. It is the submission on behalf of the review petitioner that this memoranda stood superseded by the circular of 12th of March 2018. That is not so. My lord, kindly take the circular of 12th of March 2018 action. That is not so. What kindly take, my lord, the circular.
When she was appointed as a head
AHM of this school.
Yes.
কবে appointment হয়েছে এই স্কুলে ওনাদের বলো say January 2, 2020.
2nd January 2020.
2nd January 2020. But that is again, my lord, in view of the in exercise of the power conferred under section 10C.
You are talking about 12th of March.
Well, I stand corrected. Mr. Mukherjee is correct. 18 December 2019. It's 1 month here, there. That doesn't matter. It's, my lord, now kindly take, my lord, the circular.
12th March.
12th March. In fact, my lordship had the occasion. Your lordship had the occasion to consider the impact and effect of the circular in the judgment which is sought to be reviewed.
Yes.
My lord, kindly take. My lord, again, emphasis is applied to the non-obstante clause used in paragraph 1 of the circular. That notwithstanding anything contained elsewhere, the Department of School Education may, in the interest of education or in the interest of public service for administrative reasons, direct the West Bengal Central School Service Commission to make recommendation for placing the services of any teacher, including headmaster, headmistress, and assistant headmaster and assistant headmistress, or non-teaching staff, including librarian, from one school to another against any sanctioned post. Now, my lord, kindly take, this is one, and kindly take, my lord, condition 6. So, my lord, what was sought to be superseded is that previously, suppose under the guidelines of 2002, an assistant headmistress had to be appointed within the teaching staff of the relevant school, the concerned institution. But now, my lord, those guidelines, my lord, stood overridden by reason of this particular circular, and more importantly, by reason of the statutory provision which was introduced in 10C of the Act, which was, again, your lordship had the occasion to examine and analyze. Now, my lord, kindly come to such transfer shall be made only against sanctioned post. But this circular is not a declaration of law that my lord, any appointment which was made against a sanctioned post which stood sanctioned or approved at a relevant point of time would continue to remain sanctioned with the passage of time and with the reduction of roll strength.
No, once there is a sanction pause,
yes,
that irrespective of the fact that the number of the students have gradually come down.
Right.
When
he cannot continue.
Then the government has to take a conscious decision of either withdrawing that particular sanction post. There is no difficulty; it can withdraw.
Right.
Based on these are all the policy or the administrative decision one has to take.
Right.
At one point of time, there were 1,000 students in a particular school, which need that at least 50 teachers are required to cater the need of those students.
Right.
Later on, it came down to 100. Now, against the 100 students, 50 teachers sanction posts are still there.
Right.
50 people are really employed, having nothing to do.
Right.
This is everywhere that this the more hypothetical, more probable.
Right.
I would say it may happen because number of the students may vary.
Right.
So in that event, sometimes the government has to desanction the post, either to withdraw that sanction, saying not required. Not required. So once sanction, it becomes I would say, the perennial in nature.
My lord, may I respectfully submit subject to your lordship's observations? My lord, in my most respectful submission before your lordship would be that, my lord, this circular, firstly, it does not supersede the memorandum dated 19th May 2004. This circular supersedes any notification, any guidelines which restrict the appointment of AHM or HM and transfer of HM and HM to any other school. A. Secondly, my lord, it is my most respectful submission once again. Kindly take, my lord, page, once again, paragraph to page 21. Kindly for once.
Yes.
Kindly.
Yes.
My lord, kindly take, my lord, from the this fourth paragraph from the bottom of this memorandum dated 19th May 2004.
Yes.
No assistant headmaster, headmistress should be appointed in a class 10 school unless the roll strength exceeds 750 or above for 3 consecutive years, and for higher secondary education institutions, including madrasa with higher secondary courses, unless the roll strength exceeds 1,000 or above for 3 consecutive years. Well, this is a case of appointment by way of a transfer in the case of the petitioner. I mean the review petitioner. So, in my most respectful submission, having regard to the clear language used in the circular, this appointment by way of transfer could not be made in favor of the petitioner by invoking section 10C of the Act, when, my lord, the roll strength of that particular school was admittedly and still admittedly is very poor. It cannot be. Otherwise, it requires, this review would require a long-drawn process of reasoning. The cardinal principles which your lordship continually applies. And if it requires a long-drawn process of reasoning, my lord, and it would assume the character of an appeal in disguise. No, এটা বলো না, ওটা বলো না, কারণ that is not the law. আচ্ছা বলো তো, ওনার আগে কি ওর ইচেন ছিল?
9 বছর খালি ছিল, 9 বছর।
From where to where? In fact, my lord, this review petitioner was appointed or by transfer on 18 December 2019 as the HM of the school. My lord, this post remained vacant with the drop in the roll strength. This post remained vacant for a period of 9 years prior to her appointment as HM. There was no HM in the school for a period of 9 years till December 18, 2019. So, my lord, it was not a continuous process. My lord, there was a complete break in the process, and this appointment was made in contravention of this 19 May 2004 circular, which is not, according to me, that is my humble understanding, which has not been superseded by the 12th March 2018 circular. That post, the word permanent used in that particular memoranda, would be permanent with respect to that lady, to that post for that relevant point of time. I echo what is being echoed on my other side. No, because it means that it requires hearing. it requires hearing, my lord. When it requires hearing.
Fortunately, my lord, had it been, let's say, what he said, had it been, he has accepted the offer, had it been, he had been elevated, then long hearing was not required, and he would have disposed of, he would have disposed of the matter with the 10 lines of the judgment. Or had it been he was here, then the argument would not have been taken place much.
Mala, kindly take his supplementary affidavit. Kindly take my opposition at page 20. It would go to show that whatever I am submitting today, I am submitting correctly. Kindly take page 20, which is a memorandum dated 17 January 2005. This is the last AHM who was appointed prior to the appointment of my lord Ms. Bhattacharya. My lord, kindly take the notes at the bottom.
2005.
Yes, but this is a memorandum which was issued subsequent to the memorandum dated 18th of May 2004. If appointed in an additional post, the approval should be treated as temporary for 2 years, after which the post should be got retained permanently, and the approval of the appointment of the incumbent should also be got approved permanently. But this appointment was never approved permanently. This appointment of Shashwati Sadhu, who was the last AHM before the appointment of the review petitioner in the post of AHM in the said school. In fact, my lord, she is a teacher of history. I believe, my lord, the review petitioner is a teacher of history. My lord, subject, my lord, too much energy, that's not good for any matter. No. My lord, these. But that's not the objective. The objective is to point out to your lordship, my lord, the review is not maintainable.
Yes, sir.
The objective is that the review is not maintainable, and the objective is that the 12th March 2018, the circular is of no assistance to the review petitioner. Well, these are my respectful submissions.
Few lines. 2004, he has shown it. It's just an administrative order, not by reason of the statute. 2005-15, Act has come into force. There is a change of total scenario now, entire things. How it will be governed, how things would be done by the Act is giving 10C, etc. And 2018 circular, which is in the line of the Act itself. There were 2000, and here, notwithstanding anything content elsewhere, that's the 2018 circular. The 2000 circular has lapsed, my lord, when the Act has come. Nothing is there. Second, my lord, a post, if it is sanctioned, permanent. Someone is appointed, maybe temporarily or a provision or 2 years temporary to the sanctioned post. Somewhere is appointment, letter is written, that it's not, that doesn't mean. If it is a sanctioned post, then one can be appointed. Maybe it's a 2 years. There are number of cases your lordships have dealt with. In a permanent vacancy, someone is appointed temporarily 2 years, 3 years, then it made it permanent. There is a number. It is your lordships have what has happened. Just for that reason, the review is just judgmental petition. Just kindly. Why your lordships have your lordships have reached to the finding to this application. Yes, kindly see Millard, page 32 of the application. Internal page is page 18 of your lordship's judgment, but page 32, the running page of the application.
Yes.
The PU application. Kindly come to, in the in-state case, it is not in dispute that there was no sanction post. Well, that time the state should have said, state should have placed the document. We couldn't do it. We have later on, after delivery of the judgment, we have brought this. There was no sanction post of the This is the point. Therefore, I have not argued much. He has argued much. Then no. Now your lordship decides it.
Yes. Thank you.
এগুলো আমাদের আর কিছু দরকার নেই, ছাড় না বাবা প্লিজ প্লিজ। আমাকে আর কিছু বলতে পারবো না, এছাড়া বাইরে আমরা কিছু বলার নেই। এর বাইরে এর বাইরে কিছু। And your lordships have correctly that in effectively, my lord, this is an all India scenario. All India scenario is, my lord, this is a great problem of the country has come now. Dropout. And especially, my lord, after the COVID, there is a good number of dropout all over India. Especially, my lord, in the rural places, rural schools, the female. Actually, my lord, why the midday meal was introduced? Midday meal was introduced to encourage the students, you come, at least you get your food. That's the reason midday meal was introduced. Then the nutrition, etc., etc., that's secondary factor. In a government school, government school, excepting very few in the city and some semi-town, everywhere is the dropout is there. That relevant question would be, if the dropout is there, if the students are dropping, no number is not, automatically the post is the termination or post is desanction. If it is desanction or it is termination, then again this comes in within the civil consequences. That's a different factor. It's a decision, policy decision of the government. It's a policy decision of the government.
Yes.
It's a question of active and dormant. It becomes dormant for a while. It may become active with the increasing roll strength. That's it. It's a floating concept. It's not a static concept, my lord.
Yes, that's all.
Great.
Yes.
Great.
Keep it in the next speakers for orders.
Great.
He wanted to cite certain judgments on review jurisdiction.
Lordship is so aware, my lord. No. But I'm missing.
It started with due diligence.
My lord, I initially I was telling my junior that I am not in a mood to do this matter, because my lord, I am missing a person while I am doing this matter. While I am doing this matter, I am missing that person. Actually, I had to appear in this matter because of him. I am missing that. Understand, my lord? I am not telling. So shocking to me.
I take your lordship.
And whenever nowadays, today I was, since yesterday, I was arguing a big matter, sir, which has been remanded in service matter, in the school service matter.
Do you argue in any small matter? No, always.
No. In the one matter is arguing for 2 days. This is going on. I was in take. Then, my lord, and just believe me, he was so much associated with me, and he was in so many service matters with me. Every moment I was feeling is 2 persons, my lord. Another one is Mintu Goswami. All the time, my lord, I really, when I do these types of matters, I feel his absence. Develop life.
Thank you. All the next. All the next one. 192 or 292?
292, lordship. I'm paying for 1 week time, lordship, up to 22. all officer of the concerned department to engage Gangasagar Mela, Lordship. I informed.
Malar, I have been told that he will comply with the partly order. He told me that's why Mala, because of that I am facing Mala, that's why the matter fixed today.
Lordship, I already informed to the officer concerned that the order will be completed. One part of the order will be completed. The officer says that he is coming for after 22. Thereafter, they comply one part of the order, Lordship.
Well, then record the submission because of that. I am facing my 2016.
I already contact my officer.
Do you have an objection for an adjournment? I'm simply asking. If you have an objection, no difficulty.
No, Mala. Since he has given an assurance that Mala,
so let it be fixed on 24.
24 Lordship, 22 is a coming Lordship. Then Lordship, 22 all our officers coming to Gangasagar Mela, 20 or 20 and 22 Lordship. 22 will come in Lordship.
All will be coming on 18.
8 total complete. 18 started to come in. Lordship. Lordship.
Over by yesterday. It is over.
Lordship, 25th.
It's already over. So
over Lordship, but all the management. Lordship.
Anyhow, come on 25th.
25th Lordship.
25th of January. Come next week.
Well, this is the item number content, that is 296.
296.
Let us see. We'll say
So
293.
my ladder pin is appeal.
Yes, 293.
93, my lord, I am appealing for the review applicant, my lord. Last occasion, your lordship directed me to serve on notice upon.
Lord, in this matter, Mrs. Aparna Banerjee appearing for the respondent railway, my lord. She was present in the first half, my lord, but due to the personal difficulty, she left the court, my lord.
My lord,
I pray for an day accommodation, my lord, on her behalf.
Yes. Only for today's accommodation?
My lord.
We will be taking up application on some within this week. Don't worry. But let us see.
Grateful.
My application.
For the respondent, my lord, date by Mr. Ajay Chatterjee.
Milord, here, Milord, the petitioner was appointed temporarily on probation as a LD clerk, Milord, on compassionate ground. After 10 years of her service, Milord, she was given 2 promotions. Ultimately, Milord, what happened? Milord, if your lordship kindly takes pain, Milord, to turn page, Milord.
What is the area? What the court has directed?
Court has, Milord, confirmed the order, Milord, passed by the Central Administrative Tribunal. I was reverted back to the post of the LD clerk, Milord, where I was initially appointed, Milord, and I was given promotion. And yes,
so order has
that the court did not
finality.
countenance, Milord, such action. The court did not, Milord, approve such action on the part of the Milord respondent.
What?
That without the court said no. I take you, my lords, Milord, to kind attention to the order passed by your lordship.
Straight away tell me that you
Milord,
were
I am
reverted back to your original post.
Yes.
Which you challenged before the tribunal.
That was set aside.
But the tribunal set aside that order.
No.
And the order was assailed before us.
Your lordship confirmed the order. In addition to that, what now, Milord?
Now what is the
Then Milord, the amount that has been paid, that is for a certain period of time. I ought to have been paid from the date of presentation of the petition, from the date of cause of action. Number one. Now, Milord, kindly seize, Milord.
Before the tribunal.
No. Milord, kindly seize, Milord. No. And second, Milord, I should have been.
No?
Because, Milord, I should have been reverted to the post, Milord, from the date where, Milord, the tribunal as well as your lordship's court, Milord,
This is a contempt applications.
it is between the contender and the court. May I take my lord's kind attention to the order first? Kindly allow me to place the order.
Because the facts which you have placed
the
does
fact
not really
is, Milord,
appeal us that there is any case of a
no,
contempt.
contempt, Milord, there is a glaring, Milord, violation. Kindly see what happened.
Here, what we have said and why? What we have said?
You know, your lordship said, Milord, kindly other,
page
Milord,
18.
the sentence.
Page 18 or 19?
No, it starts from, Milord, page 15.
I am talking about page 18 and 19. What?
Page 18.
19. Pay the salary attached to the post which was held by the petitioner
Yes.
before the order relegating her to the original post was passed, and shall be paid the differential amount within 3 weeks. What is your
Yes,
remark?
salary and Millard, this post was not given, Millard, to the petitioner. The post was not given.
No, the respondent authorities are directed to pay the salary attached to the post, which
Yes.
was held by the petitioner before the order relegating her to the
That
original
was
post.
never given to me.
So
That
we
was
say
never given to me.
salary to that
Yes,
and shall be paid a differential amount.
yes. So,
If
so in
already
the,
paid, the less than the differential amount.
yes, and not only that, Millard, kindly sees, Millard, your lordship's order, Millard. The tribunal in fact found, page 17, in existence of such elements and did not give any nod to such action and caused the same, which in our opinion does not require any interference. The reason being, once the authorities have knowingly promoted the petitioner to the promotional post, bearing in mind that she could not successfully clearly type the written test, even if it is termed as a mistake for the sake of appreciation, yet the petitioner cannot be put to its original post without adherence to salutary rules. To that, Millard, it is all right. Since none of the procedures provided in the statutory rules were followed, the order relegating the petitioner back to the post of junior passport assistant falls on the anvil of natural justice, which is the hallmark of any administrative or judicial action before embarking the journey of deciding the right accrued or not accrued in favor of the person. The recourse available in the statutory rules is the domain of the employer or the institution for which it is framed. And if any mandate is given for strict adherence to such rules, the infraction or departure therefrom is susceptible for interference as per se illegal or perceived to be so. Furthermore, the court cannot direct the authority to act contrary to the provision of the statute or its rules, not to make any departure therefrom, but must keep the authority within the bounds of law, as any departure therefrom would entail such action liable to be quashed and set aside in exercise of power of judicial review. In fact, the tribunal has simply activated the salutary persons to be resorted to by the respondent authorities, which cannot be conceived to the outcome of irregularity or illegality. Then your lordship said, so far as the findings which according to Mr. Basu may be projected against his client are concerned, those are restricted to the said application or relatable to the ultimate goal to be achieved while granting relief. It would neither attain finality nor intend to achieve so, but restricted to the reliefs claimed therein. Furthermore, the authority upon issuing the show cause notice in terms of salutary provision shall be guided by the materials produced before it, shall not be swayed by the adverse observation made in the order, because such proceeding is independent and not arising of the tribunal application. The apprehension in the mind of the petitioner is unfounded, more particularly that such adverse remarks would be guiding tool in the proceeding originated from the show cause notice. We seriously took note of the fact disclosed in the courts of the instant writ petition that despite the orders dated 4th November 2020 and 11th November 2020 having quashed and set aside by the tribunal, the petitioner is still treated to have been posted at the relegated post and paid the salary incommensurate therewith. The moment the order reverting the petitioner to the original post is set aside by the tribunal or the court, such order cannot be whittled down nor the effect can be brushed away, taking a circuitous route which is unfounded and contrary to the rules, fundamental principle of the service rules. The moment the order dated 4th November 2020 and 11th November 2020 set aside, the logical inference flows therefrom is that the petitioner retained at the post which she held at the time of passing the said order, and it is incongruous to suggest that she would remain in the relegated post and shall be paid the salary attached to such post. Now, I am to show that whether your lordship specific.
You appeared in that.
Yes.
That's why the language appears to be so.
Page 43 kindly comes.
Yes.
Letter written by the regional passport officer, dated 17/3/2022. This copy has been given to me.
Where?
The page 43.
Yes. 17/3/2022.
Into 2022.
Yes.
Kindly marked. Copy Pratilipi, copy to Srimati Subhra Rai, Kanisht Passport Sahayak, Srimati Junior Passport.
Where is Pratilipi?
Bottom.
Yes.
Junior Passport Officer.
No. What is this? Subhra Rai?
Subhra Rai, my client. She was addressed as Junior Passport Officer.
No, not junior. What? Kanishta?
Kanisht. Kanisht Passport, Junior Passport Assistant, English.
No.
Kanisht has a
Kanisht Passport Sahayak.
Sahayak.
See, Sahayak.
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 Sahayak. Sir, Now, my lord, then comes to 45.
Yeah.
20th April 2022. Posting order. Following officials are hereby deployed at various post office passport shops, Kendras.
Above that.
दिनांक 9/5/2022 and से 3/6/2022 तक के लिए निम्नलिखित अधिकारियों को तैनाती विभिन्न डाकघर पासपोर्ट सेवा केंद्र POPSK में मई के महीने के लिए किया जाता है.
Don't use the word Maike.
नहीं.
Good word.
Now, my lord, kindly sees that how she was addressed. 5th column. Srimati Shubhra Rai, Kanist Passport Sayak. Srimati JPA, Junior Passport Officer, Barakpur. Assistant, Junior Passport Assistant. So, my lord, the tenor. Now, my lord, the question of, now, my lord, what is my grievance? Grievance that
You have not been paid the differential amount or a salary.
my lord, the amount that has been paid, some portion, I said in a fragmented manner, and that is the way, my lord, and reverted back to, my lord, the post, my lord, which your lordships, in no uncertain terms, the court did not pass any order which is capable of two interpretations. So, if the court is certain, now, my lord, this particular, my lord, I tell your lordship what is my pleading. Kindly sees, willfully and deliberately, page 10, continuously not restoring the position of assistant superintendent and pay the salary attached to the post, including the area definition, page 10.
It was that so she was relegated back.
Relegated back.
Might have been paid that particular salary of the relegated post. Since the order of relegation was really caused and set aside by the tribunal and affirmed by this court.
Yes.
So she is entitled to retain that particular post.
Right. Right.
So what this paragraph says is that in the event she is paid less amount, then she should be paid the amount which is there before the relegated post she held, and then the differential within 3 weeks.
Yes, my lord, but what is the amount that has been, that is, my lord, in the contempt petition, my lord?
Accounting purpose.
No, accounting, no. I was never given back. I was never given back, my lord, to the post, my lord, which I had enjoyed. On the date, my lord, 4/11/2020 is an order, my lord, which stands quashed, my lord, which my lord set aside ultimately the order, my lord, which reverted back me to the post of the lower division clerk. The contempt petition, the opposition, my lord, the order of the cat, my lord, is at, my lord, in a writ petition. If your lordship kindly takes pain to the writ petition of the last impugned order, what did the cat say, which your lordships had confirmed? Paragraph 7, my lord. In such backdrop, may I read for my lords? In such backdrop, we set aside the order dated 4/11/2020 and 11/11/2020 and direct the competent respondent authority to issue a so-cause notice to the applicant within 2 weeks of the date of receipt of this order. The applicant is directed to respond to such notice within a period of 15 days from the date of receipt of such notice, and the reply will be decided upon within the next fortnight by the authorities, and if necessary by according personal hearing. 2. In the event applicant's claim brought forward in a reply is not substantiated, the competent authority shall call the applicant for a typewriting test within 4 weeks, thereafter which the applicant is directed to attend. I have done so, they have done so also, mirrored part 1, part 2. After assessing the applicant's performance in the typewriting test and having noted the provisions of the rules and instruction as relevant for this purpose, the said authority would issue their orders in accordance with law. In the event applicant does not respond to the show cause notice within the specified time period or fails to appear at the typewriting stage, the respondent would liberty to proceed in accordance with law, and no further opportunities would be given to the applicant. Consequent to issue of the final orders passed by the respondent authorities, the period during which their orders dated 4/11/2020 and 11/11/2020 are being set aside and should be regularized in accordance with law. So if, and your lordship has had also, my lord, confirmed this order, the tenor of the order. So I was, my lord, the authority was left with no option but to, my lord, secure compliance of the order. The first is, my lord, to relegate me back, my lord, to the post which I had enjoyed, my lord, before the date of 4/11/2020. And second, my lord, the salary, my lord, which I am entitled to pay attached to the post, my lord, that should be given in full, not in a fragmented manner. Now in the contempt also, my lord, I have categorically stated. Last 8. Reply to the এখান থেকে বলছি, এখান থেকে বলছি। এই তো বলছি। এর ভিতরে একটা বাস হয়েছে। Yes. Yes. Now, my lord, kindly turn, my lord, my reply, page 4. I have, my lord, tried to, my lord, explain, my lord, the position, page 4 of my reply. Yes. Page 4. Yes. My lord, I further submit, my lord, it's 13 line 3rd, page 4. My lord, I respectfully submit that there has been no averment in the said affidavit, page 4 of the reply. I'm sorry. Subparagraph. Yes, subparagraph. Yes, my lord. Affidavit in reply, my lord. Yes. I respect, page 4, my lord. I respectfully submit that there has been no averment in the said affidavit that the due process has been followed by the alleged contemners in securing compliance of the direction of the Honorable Court. There has been no material on record to suggest that the alleged contemners have taken approval from the appropriate authorities in the matter of implementation of the directions of the Honorable Court before issuing such purported final order wherein I was continued to be treated as junior passport assistant in gross violation of the judgment and order dated 2/2/2 passed by your lordship, my lord. The entire exercise is perfunctory and in gross and deliberate disregard to the said judgment and order despite having knowledge, full knowledge. I further submit that after the order of the Honorable Tribunal or the order of the Honorable Court, I have never been allowed to discharge duties as Assistant Superintendent Group B. I was issued show cause notice on 25/1/2022, addressing me as a junior passport assistant, not as an assistant superintendent. Before the purported order dated 14/3/2022 was issued, I was allotted duties as junior passport assistant and not as assistant superintendent. Only after this content petition was served upon the contemners, the purported arrear has been paid. The respondent authorities concerned have not questioned either the order of the tribunal or the order of the High Court, Honorable Court. And despite accepting the same, they have acted in gross disregard to the same. They have paid arrear salary from 4/11/2020 to 13/3/2022 on the purported basis that I have been reverted back to the post of junior passport assistant on 13/3/2022. However, in the impugned order dated 13/3, there is no whisper of any reversion. Despite the same, I am being treated as a junior passport assistant in gross violation of the judgment and order dated 2/2/2022 passed by your Lordship, Millard. And some of the, I respectfully submit that my appointment letter to the post of lower division clerk has been issued on 3/1/2002, and pursuant to the same, I have joined the post on 11/1. There has been an inadvertent error in mentioning the date of appointment. Next, Millard kindly comes. I submit that the contemners have sought to take shelter under a crafty drafting by avoiding the averment, like the contemners have complied with the order in its true letter and spirit, or that there has been no willful laches on their part securing compliance of the judgment of such and such passed by your Lordship. No explanation regarding the delay in securing part, that is for your Lordship to decide. The contemners are not apologetic in any manner whatsoever, as they did not offer any apology to the delayed payment of the arrear salary. Have taken a very casual approach while dealing with a proceeding which is a quasi-criminal in nature. The contemners have willfully avoided to comply with the directions. On the contrary, they have made a confident, incorrect statement in the said affidavit that the salary and arrear of rupees such and such has been paid to me for a period of 4/11/2022 to 13/3 while she was working in her capacity of assistant superintendent. So this was never dealt with. But the implication or the ramification of your Lordship's order that I must be there, Millard, if 4/1/2020 and the other Millard, if these are set aside, then what is the consequence, natural consequence? I put this question. Now, your Lordship, on the last occasion when the matter was heard, your Lordship had put this question to Mr. my learned esteemed senior friend, to which, if my memory does not betray me, Millard, my learned esteemed senior friend had answered that the payment has been made, which I have also accepted. It is not, Millard, mere arithmetical calculation. It is also not a fact, the case, Millard, where facts that are ignored, that does not mean that facts do not exist. The ignorance, that is a conscious omission on the part of the authority is, Millard, they have not given me the benefit which ought to have been given under the order. And that is the question your Lordship had put them on the last occasion. That why, Millard, I was not given the post, Millard, in question under this order.
Assistant Superintendent Group B.
Group. Annexure, Millard, kindly see, page 7. 7, 8, 9, only, Millard. My reply, Millard, page 7.
What?
They have treated me as a junior officer.
That is what I'm
7, 8, 9.
That is what I'm saying. That they are still Kanishta Sahayak of Sahayak Adhikari.
I will learn later on.
That's all. Don't lend your ears to your junior anymore.
No, Millard, since this matter now is taken up after a long time, Millard, your Lordship had specifically put this question to my learned senior friends that why this part was not complied with.
Because if you pass on the buck, then we can go there.
I was a little bit nervous, Millard, because since the law is, Millard, it is between the contender and the court. So, Millard, whether I have.
That's why your Lordship's order adversely, your order of the tribunal was not complied with. What cannot be done directly is attempted to be done indirectly.
Not, I shall not.
The appointment was made on a compassionate ground. And the type
That's the right. You
that
can't deny.
compassionate ground, not and then the
Show a compassion.
not no, I'm not the authority to show that. But if your lordship would, I will humbly submit that the direction granted by made by lordship in the order of lord has been totally complied with. I will try to satisfy lordship on that.
He is still having grievance of designating her or him as GPA,
which she was not entitled to under the service rule.
She was entitled to as GPA. Your grievance was, or your decision was, that she is not entitled to be promoted as assistant superintendent or the higher
up.
Because there is one condition of qualifying in a typing test. He attempted twice,
failed.
So unless he qualifies, he cannot. The tribunal said that nothing doing because it is two phases, 8 years of complete and 45 years. Then this particular provision gets waived. This is what the tribunal held. In my judgment also, there is a reference of that. It gets waived. So what we said is that the tribunal, once it says that knowing fully well that she was disqualified in a typing test, the promotion was given not once, twice, 2 stages.
Yes.
Then there is no question of taking away those rights by a mere dropping of a letter or issuance of the letter.
Those were set aside.
The entire thing set aside. So
yes.
The corollary effect of or the fulcrum of that particular setting aside of the judgment, because of Mr. Basu, I'm using those flowery words. So the thing is that order to revert back to the post of GPA was set aside.
Yes.
Was. So she remained in the last permanent post. Promotional post.
Yeah.
That is the assistant superintendent group B. She remains. She has to be there. If she's there, then you'll have to pay her the salary of that, and you'll have to treat her in that capacity. And then, if the rule permits, you can initiate a proceedings, and then, as a penalty or whatever the punishment, you can revert. It's no difficult.
If your lordship take the order of the tribunal once.
Yes.
What were the issues before the tribunal and what was decided? Can you see?
Yes.
Page 7
of
the it is segregated blood of the order of the tribunal.
Page 7
of the order of the tribunal.
Where it is, there are many copies. In a WPCT is the last page.
May I confirm? No, not in the last page. Order copy টা আছে?
Ultimately, what the tribunal held.
May I show tell lordship what were the issues? There are only 2 issues.
Page 75, it says that in view of the facts and circumstances, the appellate.
I'm coming to that.
For promotion may be considered in, I do not know, impugned order for reversal and recovery letters may be cancelled, and the applicant relief may be considered. I do not know what English it is.
I'm not Your lordship got the order of the tribunal?
Yes, that
Yeah.
is what the ultimate paragraph 6 I was reading.
Kindly come to paragraph 6, yes.
Yes, I was reading.
7, page 7 of the order.
I do not know, it is at page 75 anyhow.
No, in internal page 7 of the order. But given the statutory provisions to be confirmed as a LDC, whether the
Where you are reading?
whether the employee could claim exemption from qualifying in the typing test 1. This is 1.
Sorry, I was written notes of argument. I'm
Yes.
sorry. Internal page?
Internal page 7 of the order. Paragraph 6.
Statutory provisions to be confirmed as LDC, whether the applicant could claim exemption from qualifying the typing test and whether the authorities can act. Then ultimate decision is
And then one second one.
whether
issue.
the authorities
Whether the authorities could have
acted
acted.
reverting and deconfirming her.
Yes.
As per their orders dated such and such.
Yes,
without
yes,
according
yes.
An opportunity to
Yes,
show
yes, yes.
Then-
Kindly see the order of the tribunal now.
Correct.
Paragraph internal
Paragraph
page
7.
internal page 9.
9. Okay, I was looking at 10. Anyhow.
I'm sorry. Upon a perusal of para 2 above, it is inferred that although the competent authorities are absolutely within their right to issue orders rectifying earlier erroneous confirmation orders of an official which were passed in contravention of existing rules, instructions, whether statutory or administrative, executive or otherwise, in the interest of the non-perpetuation of the mistake and to protect the larger interest of the government, the principles of natural justice should be complied with by giving the government employee a show cause notice and an opportunity to be heard before passing any orders affecting to. Done. I will show how it is done. Done. Then, Lord, this is with regard to issue A, issue number 1. Issue number 2 is this, Lord. Then, hence, all the competent authority had referred to the provisions of so-and-so, have followed the provisions of paragraph so-and-so to have issued a show cause notice to the applicant and should have offered her an opportunity to be heard before her reversion as deconfirm orders. The Honorable Apex Court in so-and-so. In such background, we set aside the orders dated so-and-so, and direct, these are the orders, and direct the competent respondent authority, 1, issue a show cause notice to the
that you issue a show cause
notice.
Given opportunity, then you also permit him to participate in a typing examination.
Exactly.
And ultimately, 2 orders have been passed. It is
Yes.
interesting.
Yes,
It is
yes.
interesting that you did not challenge that order.
No,
You did not.
I did not.
Challenged the order in a very limited scope.
No. I did not because perhaps
Why I'm saying these words, it's not that we are putting any kind of a blame on the authorities. No. It is they who challenged this order because there was these certain directions, according to them, was not in consonance with law. Now, once the writ petition is entertained and decided on merit, taking into overall facts and the circumstances, will not the doctrine of merger applies? And if the ultimate order is passed by a higher forum, then in that event, the authorities have to respect the higher forum's order instead of relegating to a subordinate forum's order.
no, I don't join issue there.
So,
Kindly come.
what was our order?
Kindly come to your order.
Yes, please. That's why we wanted you.
Yes, kindly come to your order. And according to me, the direction given have been complied with fully. Kindly come to your order.
Yes.
Lord, your lordships have said, after the submissions were recorded, your lordships has said that we show cause notice and I don't know, internal page, running page 18, running page 17.
Yes.
The tribunal in fact found the existence of such element and didn't give any nod to such action and quashed the same, which is in our opinion does not require any interference. The reason being once the authorities have knowingly promoted the petitioner to the promotional post, bearing in mind that she could not successfully clear the writing test, she was not eligible to that. Even if it is termed as a mistake for the sake of appreciation, yet the petitioner cannot be put to his original post without adherence to the statutory rules. Your lordship's observation is this. And then, since none of the procedure provided in this statutory rules were followed, the order relegating the petitioner back to the post of junior passport officer assistant falls on the anvil of natural justice, which is the hallmark of any administrative or judicial action before embarking the journey of deciding the right accrued or not accrued in favor. So the hearing must be offered to. Yes. Now, next paragraph, not the seventh line. Furthermore, on the right hand side, furthermore, the court cannot direct the authority to act contrary to the provisions of the statute. I'm not kindly allow me that.
Yes.
Yes,
Yes. You complete, then let us exercise our power.
Maybe to your lordship's announcement, I will put it.
Yes.
Furthermore, the court cannot direct the authority to act contrary to the provisions of the statute or its rules, nor to make any departure therefrom, but must keep the authority within bounds of law, as any departure therefrom would entail such action liable to be quashed and set aside in exercise of power of judicial review. In fact, the tribunal has simply activated the statutory provisions to be restored to to be resorted to, activated by the statutory provisions to be resorted to by the respondent authorities, which cannot be conceived to be an outcome of irregularity and illegality. Then with regard to the show cause notice, I am not advancing that. The second paragraph, next page. Made in the may I place page 18. So far as the finding which according to Mr. Basu may be projected against his client are concerned, those are restricted to said application and relatable to ultimate goal to be achieved while granting relief. It would neither attain finality nor intend to achieve so, but resorted to the reliefs claimed therein. Furthermore, the authority upon issuing this...
The problem is not this. The problem is very simple. How you designate the petitioner in any of the correspondences which you make with her. You can initiate a disciplinary proceeding. You can initiate any kind of a proceeding. The free hand was already given by the tribunal, and rather we also accepted that you have to follow a statutory rules. We were very categorical that she was appointed as a junior passport officer maybe on a compassionate ground, and she was promoted, given two promotions, two different posts. The moment the tribunal set aside those orders by which you relegated her back, relegated her to the junior passport officer, that we have very, very, very vividly and very clearly indicated that the outcome of this setting aside order is that she would remain in that particular promoted post or promotional post. You cannot. Now you refer her in that post, initiate a proceeding, impose a penalty, revert back, no problem. But so long she is there, you can't treat her in that way. That is the problem which really comes.
This is exactly.
And it appears that after this order, what you have done in the April order.
May I
come to the April order?
Yes, I'm not May
22nd, which is that order?
With regard to the next paragraph, I have something to say.
Page 42 and page 45.
Come.
May I complete your lordship's order? Complete your lordship's order. I have something to say, Lord. I have something to say. I'm not.
I'm reading it faster than you. We can say we seriously took note of the facts disclosed in the course of the instrument. Read the last paragraph I'm reading. That
page.
Same page.
Paragraph page 18.
Yes, this is exactly I'm trying to.
I'm reading faster. We seriously took note of the facts disclosed in course of the instant writ petition that despite the order dated 4th November 2020 and 11th November 2020 having passed and set aside by the tribunal, the petitioner is still treated to have been posted at the relegated post and paid the salary in commensurate therewith. This says JPA. The moment the order reverting the petitioner to original post is set aside by the tribunal or the court, such order cannot be whittled down, nor the effect can be brushed away, taking a circuitous route, which is unfounded and contrary to the fundamental principles of the service rules. The moment the order dated 4th November 2020 and 11th November 2020 are set aside, the logical inference flows therefrom is that the petitioner remained at the post which she held at the time of passing the said order, and it is incongruous to suggest that she would remain in the relegated post and shall be paid salary attached to such post. What does it mean?
I'll tell you. No, this is an the observation of your lordships.
This is a conscious direction.
No, this is not a direction which I have violated. This is an observation. This is an observation by lordship with regard to. It's an observation of your lordship with regard to the order of the tribunal. This is your lordship.
Very good. Then we are passing an order in a clear
manner. I'm not your lordship.
Let us pass the direction. If the authority receive this in this fashion, then we are really.
I'm not kindly say. I have something more to say. I would not waste your lordship's time. I'm called somewhere else also there. So in other court also I'm all right. No time. I'm not the direction in the order. I read it the way. Page 19. The respondent authorities are.
I understand, but the reason was when we said that he cannot be posted at the relegated post. What does it mean? The direction could not have been done. This is what, may I say, it's a.
Yes. Okay. Opposition.
Yes. Mr. Chatterjee, come to paragraph 8 of your opposition. My brother has pointed out. Please read that.
Your opposition paragraph 50. The contemner fully realizes what he is obliged to do. So many words he says so in paragraph 8. It is further denied that no fresh order of reversion was passed or any subsequent order, and as such there is no justification in treating the petitioner as junior passport assistant. This is a stand-on affidavit, and still in the orders he is issuing, he is referring to the petitioner as junior passport assistant. This is an affidavit.
Kindly see the dates.
Yes, just see the date. It is 1 month after the court's order, 2 months after the court's order.
20th of April. Order 9th of February, she furnished 14th of March. Her representation was gone down. Thereafter, he was designated as JPA.
9th of March.
What is the date of our order? I will show you only 2 documents. What is the date of our order? 2/2022.
Your lordship,
February.
Orders are dated.
2nd February. Come to that page.
43.
Page 43.
Page 43, yes.
What is
the date?
May.
What is the date?
17th of March.
No.
Yes, 1 month.
Page 43.
17th of March.
Yes.
2022.
1 month.
1 month after the order of the trial court.
Kindly. 14th of March 9th of February, my lord, she furnished her representation.
I am asked.
After your lordship's order, 9th of February, my lord, furnished her representation. 14th of March, the order was passed by the tribunal, by the authority. 14th of March.
Which one? No, where is that page 40,
Not
43, which is
I have prepared a list of dates.
April date.
Well, not this is 17th of March. 14th of March, and the order has already been passed.
April. Please come to page 45. Come to the page 45.
I'm on page. I will come to that.
What is the date?
Page
about March.
Page 43 is the 17th of March.
45. Page 45. Sorry, I referred the wrong page. Come to 45.
But bear in mind.
No, 45. First. What is the date?
20th of April.
And how you have described the petitioner?
At serial 5.
Serial number
See
5.
what you have referred to.
Two dates. Kindly make it. Kindly make it.
We are not concerned with 16 marks.
Kindly make a note.
We are concerned with
Because the facts are facts, not I can't distort it. The two dates are important. Not she has filed her representation on 9th of February 2022 after the lordship's order, and then on 14th of March the decision was taken against her.
What? After giving an opportunity?
Yes, of course, she was heard.
What?
What
decision?
I'm not. I have a list of dates. I can tell you lordship that.
Opposition.
Affidavit, he has said that no fresh order of reversion was passed.
Never it was part of the reversion order. Because notice, what is I do not understand. I have a DP page 36.
You look at your.
Can he now go beyond the chapter? Beyond?
Your client.
Yes, page 35, 36, my lord.
Just wait. You did not have to ignite. Please come to page 8, paragraph 8 of your opposition.
Yes.
You have said, I am reading, with reference to paragraph 14 to 17 of
I am reading.
I dispute the contents therein, except for what was a matter of the record and what is specifically admitted therein. It is admitted that the petitioner made a representation to the office of the container, inter alia praying for restoration of the position. It is denied that the container number 1 passed an order addressing the petitioner as junior passport in most illegal and mechanical manner, holding that in reply the petitioner was found to be unsatisfactory. It is further denied that no fresh order.
It is denied.
No fresh order of reversion.
Or any subsequent order, and there is no justification in treating the petitioner as such and such. It is denied and disputed, and everything you have said, and then
only that.
That is the stand on affidavit. How can you improve that situation?
Only the usual order has not been passed, but the representation has been dismissed, Millard. Representation has been dismissed. No, representation has been dismissed.
The authority is trying to sit over the High Court's order.
No.
Yes, it is quite apparent.
Not far from it. Not I will.
Affidavit, he is saying that there is no fresh order, and he is still referring her to the junior post for which we have given her a remedy.
I will not defend any order of an authority, Lord, to the disregard of the court. I have never done.
That is what it appears.
No. This may have been said, but the question only that the two dates are important, Lord. By 14th of March, Lord, she has her appeal was dismissed, although the representation was given and the representation has been dismissed. If the representation is dismissed, then I borrow from your lordship's own language, observation in the order. If the tribunal sets aside the two notifications issued to the petitioner, then Lord, she comes back to the same position.
What has happened? There is a further confirmation to the post order is awaiting from the Ministry of External Affairs.
That is after she has passed out typing examination successfully. After she has passed out successfully.
Only that there is no,
forthcoming and awaiting.
The typing test was made on 24th of June 2022.
Order of reversion. How can you do that? I'm asking. It's a clear. It is an apparent. Come tomorrow. Come tomorrow. 14th of March is ordered.
That first item, may it appear as one.
Yes.
May I get two? I want to get two orders from the tribal from my client. Could it be day after tomorrow? I'm seeking 1 day's time.
Yeah.